The Rules Committee will come to order. I want to welcome our witnesses, invited jointly by myself and Mr. Cole, and I want to thank them for being here. We're going to begin with an opening statement from me and from Mr. Cole, and then we'll go to our distinguished witnesses. Today, the Rules Committee will hold a hearing to discuss how the Constitution separated powers between the legislative and executive branches, and how the balance of power between these branches has shifted over time. We are doing this in the hopes of finding concrete, bipartisan solutions to better ensure Congress is playing the role our nation's founders envisioned. That's a lot, I know. And while a constitutional debate may be fun for law students and legal scholars and Mr. Raskin,
it wasn't fun when I was
for the rest of us, it could feel a little in the weeds. So for the rest of us, let me simplify. We throw around the phrase "the people's house" a lot around here, but this really is about whether we remain the institution that our nation's founders created to be the voice of the people. The Constitution entrusts Congress with deciding how to spend federal resources and to develop policy for the entire nation on everything from health care and energy policy to trade and our nation's farm policy. It also entrusts Congress with the very important job of determining when to commit the nation to war and to put our service members in harm's way. These important tasks were put in Congress's hands because we are the closest to the people. Each senator represents an entire state, but each of us in the House represents roughly 700,000 constituents. We are on the ballot every 2 years. This puts us closer to the people, their worries, their needs, their frustrations, their hopes and their fears. It makes us more responsive to them. Because our founders determined that some important tasks demand direct input from the people. The President, the head of the executive branch, has important powers too. Among them is implementing and enforcing the laws that Congress enacts. They face regular elections as well, since there are no kings or queens in America. But sometimes presidents of both parties have overstepped and gone from enforcing policy to creating it in ways that our founders never imagined. And every time that happens, the power of Congress, the people's power, is diminished. That is what we've seen for the past 20 or 30 years now. President after president has taken more and more of the power traditionally vested in the Congress. So the question is whether we are going to implement reforms and take our power back. Across our history, we have seen Congresses do just that, like in the 1970s when the War Powers Resolution, National Emergencies Act, and the Arms Export Control Act, among other reforms, were enacted to rein in presidential power. And in the 1990s, when Congress passed the Congressional Review Act to provide better oversight over regulations. I think the time has come for Congress to push back once more, not to rein in a particular president, but to rein in all presidents, and that's with an S at the end. Some people may wonder why we're doing this now. Well, I think this is the perfect time to do it. We're in an election year. We don't know who the next president will be. But what we do know, if history is any indicator, is that the next president is not going to have an epiphany and just hand Congress its power back. We need to seize it. If the next president is a Republican, I know I'll want to assert my full constitutional authority. And I guarantee that if he or she is a Democrat, my Republican friends will too. So this is bigger than who will win the next election, because when the executive doesn't consult with Congress, doesn't notify Congress, doesn't submit to oversight by Congress, sends our troops into harm's way without Congress being part of that discussion, it's not just this institution that is on the losing side of the tug-of-war with the executive, it's our constituents, the people we represent. Those people are the ones who lose. So before we introduce the witnesses, I'd like to discuss our format today. Our panel does not consist of majority or minority witnesses. The witnesses who have been called to testify today have been called by our ranking member and me jointly. And we relied on the Congressional Research Service to help us with background materials because we wanted just the facts. Next, while we will ask our experts to keep their opening to 5 minutes, our members are free to ask questions for as long as they'd like. Now, brevity is always rewarded, but we want to make sure that our members and our witnesses have ample time to discuss the issues. For the sake of this hearing, I would like to think that there are no Democrats or Republicans. Finally, the only reason why we have been able to maintain a bipartisan approach, and I want to note this for the record, is because of our ranking member, Mr. Cole, and his very talented staff. You continue to be a collaborative and helpful partner, and I so appreciate you and your commitment to this House, as well as my staff and the members on both sides here. So our hope is that this process will help us find opportunities to reassert congressional authority that both sides can agree on. And having said that, I'm happy now to yield to our ranking member, Mr. Cole, for any remarks that he wishes to make.
Thank you very much, Mr. Chairman. I have a couple of off-the-cuff remarks before I get to my prepared remarks. Normally when I come into this committee, I always walk in thinking it's 9-4. Today, I think it's 13-0. Because frankly, whether you're a liberal Democrat or a conservative Republican, whichever side of the philosophical or partisan divide you're on, I think there's probably a common sense throughout Congress, honestly, not just on this committee, that there's been a many decades-long erosion of congressional authority, and that it's time to do something about it. We're also 13-0 today because we're all students, and you're the instructors. And in fact, some of us did our homework this weekend. I noticed Mr. Perlmutter cramming right to the last minute. He was reading the testimony, and all of us probably are a little bit of awe of you, except, again, Mr. Raskin, as the chairman pointed out, since he's academically on a par with all of you. But we're very grateful for your participation. And, Mr. Chairman, let me add again, I'm very grateful for your leadership. Once again, you've established the Rules Committee as the model for civility in Congress, a new and unaccustomed role for us, but one that we proudly claim under your leadership. Today's original jurisdiction hearing covers what, in my view, is one of the most important issues facing Congress: the scope of Congress's power under Article 1 of the Constitution and the impact of separation of powers on governance. I want to thank Chairman McGovern for arranging today's hearing. Though the chairman and I disagree on a lot of things, the constitutional authority entrusted to Congress is not one of them. Indeed, we are both equally concerned about protecting Congress's power under Article 1 of the Constitution, and we are both equally concerned about the erosion of that authority over the past several decades. Though the shift has been gradual, Congress has not only ceded its authority at times, but presidents of both parties have also claimed powers that belong to the legislative branch. The Constitution very clearly vests all legislative power in the Congress of the United States and all executive power in the President of the United States. This was carefully crafted to create a system of checks and balances that prevents any one branch from becoming too powerful and allows our republic to thrive. So why then does Congress over the years consistently allowed the reduction of its own authority? I'm hopeful that our witnesses today will shed some light on this and discuss where practices of the past went wrong. And I think probably all of us as practicing politicians and legislators have some pretty interesting thoughts on, again, where we see we've fallen short in many cases of living up to our own responsibilities. With today's hearing, we will hear from 4 experts who allow us to put all of this into perspective. We will hear about the constitutional provisions affecting both the legislative and executive powers, and we will hear testimony on the history of how this has all unfolded. And we will hopefully hear recommendations on what Congress can do to reclaim its authority. At the end of this process, we may learn that there really is nothing specific Congress needs to do to reclaim and reassert its constitutional authority other than act decisively to do so and utilize the tools currently available to us. Or we may discover that substantive changes do need to be made. Either way, I'm hopeful that Congress can act in a bipartisan manner to effectively use the legislative power should it choose to do so. Today's hearing at the Rules Committee is an important first step in making that goal a reality. Finally, I want to invite us all to remember and ponder this. When our founders envisioned the grand American experiment and put pen to paper on the distribution and separation of government powers in the U.S. Constitution, they first described the powers entrusted to Congress on behalf of the American people. Indeed, perhaps the greatest power of the legislative branch established in Article 1 is how closely connected it remains to the views of the nation's citizens, as my good friend, the chairman, pointed out. With that, Mr. Chairman, I want to thank you again for calling today's hearing. I want to thank our witnesses for being here today and for sharing their insights and expertise with us. And I want to thank the staff on both sides of the dais for their hard work in putting this hearing together. Thank you, Mr. Chairman, and I yield back.
Well, thank you very much, and I'm now delighted to introduce our panel of witnesses. Matt Spalding is the Kirby Professor in Constitutional Government and Dean of the Van Andel Graduate School of Government, as well as the Vice President of Washington Operations at Hillsdale College. He is the best-selling author of We Still Hold These Truths, Rediscovering Our Principles, Reclaiming Our Future, and is also executive editor of the Heritage Guide to the Constitution. Deborah Pearlstein is a professor of law and co-director of the Florsheim Center for Constitutional Democracy at Cardozo Law School. Prior to this, she served as an associate research scholar in the Law and Public Affairs program at Princeton University. Laura Belmonte is a professor of history and dean of the Virginia Tech College of Liberal Arts and Human Sciences. She is co-author of Global Americans, a transnational U.S. history, author of Selling the American Way, U.S. Propaganda in the Cold War. She served on the U.S. Department of State's Advisory Committee on Historical Diplomatic Documentation from 2009 to 2019. Sai Prakash is a James Monroe Distinguished Professor of Law and Paul G. Mahoney Research Professor of Law and Senior Fellow at the Miller Center of Public Affairs at the University of Virginia. He is also taught at Princeton and the University of San Diego School of Law. He clerked for Justice Clarence Thomas. Thank you again for all for joining us. And I'm going to begin with Ms. Belmonte. You are recognized for your testimony. Yeah.
Good morning, Chairman McGovern, Ranking Member Cole, and members of the Rules Committee. Thank you for the opportunity to participate in this hearing on how Congress might reassert its constitutional authority and redress the current imbalance between the executive and legislative branches. I appear before you as a scholar who has studied the history of the United States for over 30 years, particularly the history of U.S. foreign relations. I've spent my career explaining how and why the role of the U.S. government has shifted over time. In my academic work and public-facing scholarly activities, I have tried to present dispassionate explanations of the machinery of government, the actors who affect public policy change, and the reasons why certain events and individuals arise. My key aims today are to place the current state of affairs into historic context and to stress that the present imbalance between the executive and legislative branches is a result of a decades-long shift, not a recent turn of events. The United States has one of the most brilliantly conceived and enduring frameworks of government in the history of the world. The Constitution's articulation of separate powers for the three branches of government is the very essence of that system, a reflection of the framers' fears of concentrated power. In preparing this testimony, I have reflected upon the final day of the Constitutional Convention in 1787. Eager for news about what type of government the framers had created, a crowd waited on the steps of Independence Hall. When Benjamin Franklin appeared, Elizabeth Willing Powell, the hostess of one of Philadelphia's best-known political salons and wife of the city's mayor, asked Franklin, "What do we have, a republic or a monarchy?" He famously replied, "A republic, if you can keep it." We as a nation are at a critical juncture where substantive action is needed if we are to keep the democratic republic the framers envisioned. The fact that you are convening this hearing is proof that you also recognize that. I am honored to be part of the discussion.
Dr. Spalding.
Chairman McGovern, Ranking Member Cole, members of the committee, thank you for inviting me to testify to the Committee on Rules. Like many of you, I'm concerned about the decline of congressional power relative to the modern executive, and I hasten to also add that this is not a recent development during this administration, the previous administration, or many before that. The sustained expansion of the executive and the prolonged narrowing of the legislative branch, in my opinion, are symptoms largely of a decades-long change in American government towards administrative rule. Result is a structurally unbalanced relationship between an increasingly powerful executive and a weakening legislative branch seemingly unwilling to exercise its institutional muscles. My testimony makes 3 general points. First, the old ways of constitutional government have been replaced, for the most part, by a new form of bureaucratic rule. By the old ways, I mean the rule of law based on consent, government of delegated enumerated powers, 3 separate branches, each with distinct powers, duties, and responsibilities, separation of powers to prevent the concentration of power, encourage cooperation for the common good. The basic power of government is in the legislature, because the essence of governing is centered on the legitimate authority to make laws. Congress's most important power is control of the government's purse, as a check on the executive and the authority by which the legislature shapes national affairs. The President is vested with unique constitutional powers that do not stem from congressional authority. This is especially the case when it comes to war and national security. The executive power is not unlimited, however, as the grant of power is mitigated by the fact that many traditionally executive powers were given to Congress. This system was further divided between the national and state governments in a system of federalism, leaving ample room for self-government. The practical result was that the United States was centrally governed under the Constitution, but administratively decentralized at the state and local level. This began to change after the Civil War, when progressives advocated more administration and a new form of governing they called the administrative state, to remove or circumvent structural barriers and make government more unified and streamlined. Presidents of both political parties, Theodore Roosevelt and Woodrow Wilson in particular, advocated expanding the administrative role of government, which meant expanding the executive branch. The most significant shift in this balance of powers occurred more recently, in my opinion, under the Great Society and its progeny in both parties. Agree with the policies or not, this expansion of regulatory activities on a society-wide scale led to a vast new centralizing authority in the federal government and a vast expansion of regulatory authority in particular. My second point, both Congress and the presidency have adapted to these new ways, but in the legislative-executive battle to control the bureaucratic state, the executive has a distinct advantage. Congress was the first to adapt itself to this process by increasingly turned to back-end checks, such as the legislative veto that the Supreme Court declared unconstitutional, and has come largely to focus on post-budgetary oversight and after-the-fact regulatory relief. The rise of what I like to call the neo-imperial presidency should not be that surprising, given the overwhelming amount of authority that has been delegated to decision-making actors and bodies largely under executive control. As Congress expanded the bureaucracy, creating agencies, delegating lawmaking authority, losing control of the details of budgeting, focusing on post hoc checks, the executive has grown. And this is the general, add to this the general breadth of legislative granted executive discretion, as well as sometimes poorly written and conflicting laws. And the modern executive can more than ever lead the bureaucracy to the president's policy ends with or without the cooperation of Congress. And in this competition to assert legislative or executive branch control over the fourth branch of government, the executive has a distinct advantage because administration, as Hamilton reminds us in the Federalist Papers, is inherently executive in nature. My last point, the proper remedy to this imbalance is for Congress to reassert its core legislative powers. First, Congress must reassert its legislative muscles, not to paralyze the government, but to command it. The courts are not going to solve the larger problem. And I think Congress is on stronger ground when it exerts its core legislative powers, where the executive plays a secondary role. So, for instance, using the budget to control executive war powers. Second, Congress, as much as possible, should cease delegating the lawmaking power and should not flinch from using its legislative powers to reclaim it. Congress should insert itself more in the regulatory process, perhaps through a regulatory budget or vehicles like the REINS Act, in order to restrain the executive's ability to make laws without legislation. Third, regular legislative order, especially the day-to-day back and forth of budgeting and overseeing the operations of government, will do more than anything to restore Article I. If Congress objects to the extent of executive discretion, for instance, Congress needs to narrow that discretion through statutes that are clear, precise, and unambiguous. And fourth and last, Congress is at its strongest, I believe, when it exercises the power of the purse. Strategically controlling and using the budget process will turn the advantage back to Congress, forcing the executive to engage with the legislative branch and get back into the habit of executing the laws enacted by Congress. Thank you.
Thank you. Professor Pearlstein?
Thank you.
Sure your mic is on. That's all.
Oh, thanks. Thank you. Chairman McGovern and Ranking Member Cole, members of the committee, thank you for your leadership in convening this bipartisan hearing and for the opportunity to take part as you consider ways Congress might reassert its authority under Article 1. Well, my written testimony offers some explanations for and some recommendations for correcting our current skewed balance of powers among the federal branches. In these brief remarks, I'd like to just share several of the broader understandings that inform the testimony I provided. First, while members of this committee well know that the Constitution's basic architecture allocates particular limited powers to Congress in Article 1 and to the President in Article 2 and to the courts in Article 3, teaching constitutional law to first-year law students has reminded me repeatedly that the lessons of high school civics don't always stick as well as we might hope they do. Among other things, without fail each semester, at least some students express surprise when I put up on PowerPoint slides right next to each other a list of Congress's powers on the one hand and a list of the executive's powers as printed in the Constitution on the other, that Congress's list is so very much longer than the list of powers granted to the executive. This is, of course, true not only in matters of fiscal and economic responsibility, but also national security and foreign affairs. But while, for example, the president has the power to negotiate treaties and receive ambassadors, and is our armed forces commander-in-chief, the Constitution gives to Congress a far lengthier list, not only to declare war, but also to regulate commerce with foreign nations, define and punish offenses against the law of nations, make rules for the government and regulation of the armed forces, appropriate funds to provide for the common defense, and indeed defense spending every 2 years in public the Constitution requires. And indeed, should the framers have left anything out in any of those powers, Congress is given the catch-all authority to make all laws which shall be necessary and proper for carrying into execution any of those. But it's not hard to see where the student's surprise came from. Popular accounts have long described an imperial presidency that regularly deploys military force with no regard for congressional preferences. Executive branch lawyers and others regularly invoke memorable, if not judicially meaningful, rhetoric about the president's signal role in foreign affairs. Even members of Congress and the courts talk frequently about the president's unique expertise in this realm. And this rhetoric and this popular story matter. So by now, we shouldn't be surprised to find, as one recent poll did, that only a third of American college students can correctly identify Congress as the branch of government with the power to declare war. In short, we have some work to do in the first instance to remind others in Congress and the American people that the Constitution assumed Congress would have access to its own expertise, and Congress, not the executive, would be the primary agent of change in setting U.S. national policy, foreign and domestic. Second, the scope of congressional delegations of authority to the executive is undoubtedly among the reasons why Congress feels frustrated in its ability to constrain executive power today. Yet while some are understandably focused on the role of administrative agencies writ large, among the most significant delegations of power to the executive are found in statutes that give authority to the president alone, triggered by factual or policy determinations made solely by the president himself. These delegations aren't to the administrative state, they are to the president. A few such statutes relate to war powers directly, most famously the 2001 AUMF, but the vast majority of statutes of this type address other federal policies, from trade sanctions and domestic emergencies to economic regulation and even immigration. These delegations are particularly worrisome in my view, but they're also particularly likely, or should be particularly likely, to generate bipartisan interest in correcting. They're particularly worrisome because unlike broad delegations of power to administrative agencies, the president is not bound in exercising these powers by the Administrative Procedures Act, a statute that requires agency decision-making to involve input from experts and other members of the public and subjects them to judicial review to ensure they're reasoned and supported by facts. Presidents may decide to consult their expert advisors. They may decide to follow an internal process, but the APA itself doesn't require them to do so. It's for this reason that both parties should be interested in making reforms at this level. While it may be essential in some circumstances to afford the president flexibility to respond to particular national emergencies, it's difficult to understand why any such response is not informed, not required to be informed by our nation's best possible expertise. Finally, I want to caution against any temptation to see delegation as such or administrative agencies as such as a bad or uniform thing. As recent events make clear, we need an effective CDC, we need an effective NIH, we need effective departments of state and defense and others. And delegation of powers to these and other agencies are an indispensable tool of good governance. But delegation is not an on-off switch. What makes it good or bad, more or less effective, depends in significant part on how well Congress chooses from its broad suite of tools to channel and monitor administrative discretion. From providing concrete statutory guidance about what and when Congress believes action is needed, to imposing restrictions on the exercise of that action, like requiring the president to consult with Congress or with relevant experts, document findings, or imposing automatic termination or sunset restrictions that prevent delegations from lasting in perpetuity. With meaningful tailored reforms, Congress can succeed both in reclaiming its power and in improving the effective functioning of government for all Americans. Again, I'm grateful for the committee's efforts and for the opportunity to share my views.
Thank you, Professor Prakash.
Dear Chairman McGovern, Ranking Member Cole, and other distinguished members of the committee, it's an honor and a pleasure to be here today. In my view, the first branch risks becoming the second branch. What was formerly a branch with great power and great responsibilities has gradually ceded its authority to the executive or sat idly by while the executive seized the authority. Where we are today, I think we find ourselves in a point in time where the executive branch continually adds to its own authority. If a previous president or presidents have taken some act, those acts form the building block of subsequent acts of future presidents, and it's a bipartisan problem. And so transgressive acts become the material, if you will, of a new constitutional conception. And this happens over and over again, both statutory and constitutional contexts. My colleagues here have mentioned the war powers of the Congress being usurped by the president, and that's certainly an instance where the president or presidents over time have claimed authority to wage war, basically in the constitutional terms declare war on their own authority, and have decided that you have lost that monopoly. I think similarly, presidents have acquired various lawmaking authorities from you. Sometimes it's delegated by you, sometimes it's seized from you by the president. And these are revolutionary changes in our constitutional structure, because now the president, I think the presidency, the executive branch, understands that it too is a lawmaker in various ways, either through the rules that you've authorized them to make, but also through various creative forms of interpretation. How did we get here? I think 4 factors help explain how we got here. Presidents today conceive themselves as policy reformers. They don't view themselves as principally executive officers. And in fact, when presidents talk about their law execution role, people are a bit confused by it. They think the Attorney General is the chief law enforcement officer. I think by the Constitution, the president is. This mindset makes it more likely that it makes them more likely to usurp power because they run on a policy platform and feel like they have to implement it. As you are well aware, presidents are also party chieftains, and they expect and receive support for their initiatives from their co-partisans almost without regard to whether the initiatives are legal or constitutional. And this, of course, gives them tremendous weight in the public mind and, of course, within the halls of Congress. Presidents have a mighty bureaucracy at their backs, supplied by you, right? The lawyers in the executive branch and the White House counsel and in the Office of Legal Counsel and all the executive officers are supplied and funded by you. And then the final factor, I think, is a more general factor, and it relates to the idea of a living constitution. If Congress can acquire new authorities by a practice, if the courts can reform our conceptions of constitutional rights, it is little wonder that presidents believe that they too can reform the office of the presidency. And I would submit to you that the presidents are most able to change our Constitution because they're most able to act with speed, decision, and repetitively in a way that creates new facts on the ground. I did not put my timer on, unfortunately.
No, you are fine.
Am I
You are
fine?
fine.
Okay.
You are fine.
So whether we are tending, to quote Abraham Lincoln, I think the continued concentration in the hands of the executive is what we can see in the future if reforms aren't made. If the war powers and the legislative powers of Congress can be seized by a president, what can't be seized by our chief executives? you risk becoming a college debating society or a potted plant, in the words of Brendan Sullivan, famous lawyer. I have a chapter of a book that's going to come out very soon that I want to share with the members. This is for the chairman himself, but I'd like to perhaps have you all take a look at it. The last chapter, chapter 9, describes 13 reforms that Congress can enact unilaterally, obviously either with the president's consent or over his veto. I think Congress ought to bulk up its staff. I think it's very hard to fight a behemoth when you're David. You need more staff, and they need to be paid more. I know that the staff would like to hear that. But I also think that there shouldn't be a situation where the minority staff turns over, or when a majority becomes a minority, that the staff are immediately fired. It doesn't make sense to me that you are running yourself on the cheap in a fight with an executive behemoth. I would, maybe I disagree with Professor Pearlstein. I think that delegating legislative power to the executive branch, either the president or otherwise, feeds the sense that the president is a lawmaker. And I don't think you can do that without that mindset seeping into the executive branch. And so I think you should certainly curb back all the delegations that go to the executive branch and the administrative agencies. It's your job, not theirs, to come up with rules. And if you are going to delegate, make those delegations sunset. And if they are going to create rules, make those rules sunset and make them or you reenact them. I think I would try to get members of Congress to think more about executive privilege. I think in the modern era, it's basically a means of stymieing your investigations. I don't doubt that presidents need confidential conversations, but when we see those conversations spill out daily in the Washington Post or the New York Times or in books, it's sort of odd to think that whatever doesn't make those pages has to be kept from you as you go about investigating the presidency and the executive branch and thinking about whom to impeach. And then two other final reforms. I think that you can incentivize bounty hunters to police the executive branch's compliance with the law. As you know, there are key TAM and former actions that go back to the first Congress. They basically authorized individuals to inform on executive officers who were absconding with federal funds, and I think that sort of system can be used to police the appropriations power that you folks should enjoy, and also police the war powers. And that's my last resolution. The war powers resolution should be strengthened. I think the way to strengthen it is just to have an automatic cut in appropriations if the president chooses to take us to war, and maybe an automatic cut to weapons programs in particular, because the military is not going to want to see its budget cut in order to wage war against some nation overseas. I agree with Chairman McGovern. The best time is now. No one knows who the next president's going to be. No one knows who's going to control the House or the Senate. And it's precisely in this climate of uncertainty that people can put partisanship aside and act in the best interest of the nation. Thank you so much.
Thank you very much. I want to thank you all. We have a distinguished panel here. Thank you for your excellent testimony. Before I go to my questions, I just want to acknowledge in the audience our former colleague, Congressman John Hostetler from Indiana, who's here, and great to see you back, and so thanks for coming. The Constitution puts the power to declare war in the hands of Congress and the power to wage war in the hands of the executive. And in some ways, this seems pretty simple, particularly when you think about how things were at the founding. I mean, Congress controlled the funds. There was no standing army. The president barely had staff, and the president had to come to Congress for funds to do just about everything. I'm sure I've oversimplified all of that, but bear with me. As the nation grew, things got more complicated. Today, we have a large standing army. The president has, let's just say, a lot of staff. Congress still controls the funds, but presidents seem more and more willing to move money around to suit them. Starting in the 1950s and then coming to a head in the 1970s, we saw presidents of both parties engage in military actions, sometimes without Congress's knowledge, let alone consultation or approval. To stop unauthorized protracted wars like Vietnam, Congress passed over a presidential veto the War Powers Act in the mid-1970s. Key to that Congress's reform effort was inclusion of a legislative veto, where through a concurrent resolution by both houses, Congress would be able to stop a president's unauthorized military action. And with the War Powers Act, Congress did not delegate any new authorities to the executive. Instead, Congress was merely setting up a mechanism to ensure consultation, notification, and communication with the executive on questions of war and peace, a communication that could be enforced with a legislative veto of a president's action. Then, INS versus Chadha rolls around, an immigration case in 1983 that invalidated legislative vetoes across the board. So one of the consequences of the Chadha decision is that we went from needing a majority of Congress to make a war and to also make peace, to needing a majority to make war, but a likely supermajority to make peace. This is an absurd outcome and has been an absurd reality here in the Congress. So my first question, and some of you have touched on this, is this. In the wake of the Chadha decision, is it time to update, reform, merely do some housekeeping around the War Powers Act to ensure that the aims of the act, again, consultation, notification, and communication are achieved? I mean, I open this to anybody. Professor Pearlstein?
Sure. The short answer is yes.
Yeah.
I think there are, in fact, there have been a number of efforts. There was a wonderful bipartisan commission that included Senator McCain some years back. There have been a number of efforts to propose changes to the War Powers Act. I think many of these recommended changes that are out there are very good. I think there are a couple in particular that warrant consideration. One, you mentioned secret wars, and the way the current War Powers Act is framed, it attaches the notification requirement, the reporting requirement, to the trigger that starts the 60-day clock, after which, right, the president is supposed to seek congressional authorization. You can readily detach that reporting requirement from the notification trigger. I support funding cutoff, automatic funding cutoff mechanisms. The traditional story is indeed with multiple conflicts, including Venezuela, which I testified about last year. Before force is used, Congress's view in a bipartisan way is we don't want to constrain the president's flexibility. And after force is used, bipartisan members of Congress say, well, we don't want to interfere or compromise or undermine troops on the ground. Those are the before and after arguments invariably in every use of force, which is why a war powers, a framework statute, and a funding cutoff mechanism, I think, is necessary. I guess I'll here just mention one other thing, which I think is really important, and that is the definition of hostilities. The current War Powers Act sets up as a trigger the requirement that either the funding must be in my amended version, the funding would be cut off, or in the current version, the president must seek congressional authorization anytime forces are introduced into hostilities or a substantial risk of hostilities. Over the years, presidents have interpreted, Democratic and Republican presidents have interpreted that word, hostilities, more and more narrowly, such that even vast uses of force, sustained air campaigns in foreign countries and so forth, presidents have argued don't count as hostilities triggering the requirements of the act. We need a much meatier or more specific definition of what kinds of hostilities we're talking about, one that's not specific to domain, meaning Army, Air Force, Navy, Marines, cyber, right, but that encompasses the range of ways in which the U.S. government is now capable of waging hostilities.
Thank you. Professor Prakash?
I agree with much of what Professor Pearlstein said. I guess I'd be wary of trying to amend the act, because the act, as originally understood, did not authorize the president to use force for 60 or 90 days. But in practice, the executive branch believes that the act either authorizes the use of force for 60 or 90 days, or is written in such a way as to assume that the president has constitutional authority to use force for 60 or 90 days. And so if you just tinker with it, those pre-existing understandings will continue on. I think you're better off starting from scratch, importing whatever you think is useful from the act. And I think the fundamental question is, do you want to essentially authorize the president to engage in war or use of military force for some small period of time and then have that authority automatically expire? Or do you want him to always come to you first? And I think once you decide that, then you can construct a new war powers framework that's consistent with the Constitution and consistent with your desires.
Yeah, no, and I personally, you know, wherever it's possible, would like the president to come to us first and get authorization. I guess if you know, we had former presidents here, They would say, well, there are national emergencies, there are things, there may be something we have to act immediately, and you may be in recess, or we can't get you all here. I mean, I think that's the, that's, some of the pushback you get. Dr. Spalding?
Yeah, I mean, that really goes to the heart of the problem. To put it in very broad terms, the more you want to legislate it, the more problematic it gets, and the stronger grounds the president is on to not abide by it. I mean, it's no coincidence every president, both parties, has considered the War Powers Resolution to be unconstitutional as a restriction. Now, that doesn't mean there's not a ground somewhere to find a way for Congress to influence that discussion, but it goes to the inherent problem of, look, how do you have a Republican form of government? The founders debated this, the Pacificus and Helveticus discussion, in which the legislature is the dominant power, especially when it comes to the general operation of government, but you created in a Republican, small r form, an executive who is capable of energy, action, immediate things that Hamilton talked in Federalist 70. That balance is extremely hard to establish. The things, the more things Congress does that puts timelines and hampers the executive, they're naturally going to pull back from that. And I think that courts increasingly, as in general, will side with the executive because of the sheer necessity of having that ability to occur and keep government safe. That's one of the reasons why, in thinking this through, in many ways, for a lot of the same reasons, I'm inclined to, as was generally the case, I think Congress is on stronger grounds when it's shifting to its primary powers, such as the purse, as I've emphasized in my testimony, as a way to control that. If you wish to control the president's activities in this expanded notion of what they can do in international affairs, then don't fund them. You have the power not to fund, which means if you don't do it, they can't actually do it. It doesn't require a supermajority to overcome something. You can pull that power back. I think those powers that Congress has are very strong, and you should go to your strength first. When you start going out and trying to put timelines on the executive's powers, I think Congress should exert that. They should push. They should disagree. But I think you're just naturally on weaker ground.
Dean Belmonte?
I think that one of the things you need to be very careful about is what constitutes an emergency. Even prior to the era when the War Powers Act existed, you have two pretty salient examples. In June 1950, when North Korea invaded South Korea, Harry Truman took advantage of the fact that the Soviet Union was temporarily boycotting the UN Security Council for its refusal to seat communist China, and therefore was not there to veto a resolution to put a multinational force in Korea. This became the first, but certainly not the last, unilateral presidential action that committed the United States to a long-term conflict in which over 33,000 Americans eventually died. Then the second example, of course, occurred in August 1964 in the Gulf of Tonkin, when the Johnson administration used two episodes, the second of which was determined not even to have occurred, but that was long after Congress quickly and without hearings of any kind spirited the resolution to passage. Only two senators, Ernest Greening and Wayne Morse, voted opposed to that resolution, which basically granted the president unlimited authority to wage war in much of Southeast Asia. So the context matters, and taking the time to determine the veracity of the justification is critically important.
Thank you. Professor Perlson, you want to?
If I may, yeah. I wanted to just maybe clarify or emphasize a couple of points. First, I quite agree, and the framers quite agreed as well, that the president has within his own Article 2 powers, the power to, the language is from the convention, repel sudden attacks. Right? So there has never been an argument that the president lacks the power to, for example, defend the United States or Americans from attack in immediate circumstance or where that threat is imminent. The good thing that the War Powers Act does is not, or an amended War Powers Act could do, or a new statute that accomplishes something similar, is not disable the president from continuing the use of force, right? So if you had a funding cutoff after 60 days, for example, that automatically takes effect, it's not that the United States can't fight the war any longer. It's that it requires Congress to vote to fight the war continuously, right? This is a straight-up political accountability mechanism that is designed to make the American people and their representatives feel and bear the costs of war.
All right, I'm happy to, Dr. Spaulding?
I think that despite the fact there will be all sorts of disagreements when you get into particulars, I think in the broad sense there's probably great agreement, which is that at one extreme, the president clearly needs to have the ability to respond to immediate threats, which could be somewhat broadly defined. But on the other hand, the actual taking the United States into a situation of war in which the whole country is at war with another country, or in a broadly determined sense of what war is, I don't think there's as much disagreement there. The harder cases are all those things in the middle that I think are somewhat unanswered. I mean, the Congress, the convention did specifically use the word declare war, which I think they meant a formality of taking us into a situation of warfare. And just the other thing I think you should think about is on this notion of if the president has done something, there should be automatic cuts. Congress can do that at any moment if they choose to. They don't need a certain amount of time for it to occur automatically. I think Congress should make those decisions and push back at any moment they choose to do so.
But with respect, I mean, Congress won't, and that's been one of the problems. I mean, that's one of the reasons why, I think having this hearing, and trying to look at some of these issues is so incredibly important. I'm focused kind of on war powers right now, and we back in 2001 and 2002 we passed an AUMF. I think like 17% of the members of Congress who were present when we voted for that are still here, and yet when Republicans were in charge and our Democrats were in charge, we don't have the political will or whatever to get up and to readjust it or to sunset it or to have these debates. I mean, we should, and there's nothing that prevents us other than sometimes partisanship gets in the way. Sometimes when the president is somebody of our party, we don't want to put that person in a bad light. But the fact of the matter is, I don't think any of us who were here 18, 19 years ago thought that we would still be using that same AUMF to justify, the military actions that we're taking today. And if you think about it, if we don't do anything, 100 years from now, you could have a president, go back to the 2001, 2002 AUMF to justify some action. So I mean, part of the challenge here is that we can affirmatively do some stuff, but I think we're going to have to we have to put some checks and balances in place that force us to do some stuff, and people can vote whatever way they want. And I'm going to yield to Professor Prakash in just one second, but I mean, my view, and I've said this because I've been very, very frustrated about, and my friend Mr. Cole and I, we share this concern over, over this, these AUMFs that, were passed a long, long time ago, is that I think we do such a disservice to the men and women who are, in harm's way that we don't even discuss these things. We're not. Our mission in Afghanistan, for example, has changed so many times. And then the way it's been kind of interpreted is that we're using it to justify a number of military operations around the world, and it just doesn't seem right. So I think a lot of times we don't want to. We don't want to take on some of these things because they're controversial. Look when you cast a vote on war, it is a tough vote. It's probably the toughest vote anybody takes. And and we've had members who have voted for some conflicts that were popular at the time that then became unpopular, and they have to deal with the political repercussions. And I'm sure the reverse is true. But that's our job, and I think sometimes we're guilty of moral cowardice when we don't take on some of these things. So I think what we're trying to figure out is, are there ways to, no matter who's in charge, no matter who the president is, that when we're dealing with some of these issues where clearly our authority is being usurped, that if we don't have the moral courage to insist that there's some sort of a procedure or process in place that forces us to deal with it. I'll just yield to Professor Prakash, and I'm going to go to Mr. Cole.
Well, Chairman, I completely agree with you. Political scientists describe a rally around effect once a war has begun, and the war is very popular. It'll be very hard at that point for members of Congress to pass a statute that cuts off funding over the president's expected veto. I think expiration dates serve useful purposes, right? Library books come with a date that you have to return. If you don't have it, you'll just keep it for months or years, right? Because you might eventually get around to reading it. I think Professor Spalding and I have a difference of opinion on the scope of the war power. The power to declare war is the power to go to war, to use military force. And in the 18th century, most wars were declared from the mouths of cannons and attacks. They weren't actually started with a formal piece of paper. This power was given to Congress so that Congress would decide whether to wage war, full stop. No early president ever thought that they could just use force against a foreign nation. Right? All the uses of force in the early years were authorized by Congress in the Washington administration, the Adams administration, et cetera. So I think the Constitution has a belt, rope, and suspenders approach to war powers. You decide whether to wage war, you can decide how to wage it, and you can decide to cut off the funds. But relying upon the last thing as the only means of defense is a mistake. And finally, the emergency point, if you gave the president emergency authority to use military force until 10 days after Congress next met, that would be sufficient for him to deal or her to deal with the emergency. And then you would decide whether to continue. And I don't think there's anything wrong with that.
No, I appreciate that. And I just, the situation we're in right now is that if Congress were to vote to cut off cut off funds for a war that a particular president, didn't want to admit was failing or was wrong, we would need a supermajority because we'd have to override his or her veto. So it might make sense, or at least worth considering that you put in a provision, where there would, after a period of time, if Congress didn't vote, you would automatically cut off the funds or something like that. I'm just, because the other thing I've learned, I studied history in college, and you read the books on the war in Vietnam, for example, and one of the frustrating things is you read now, after all these years, all these accounts of how presidents knew that it wasn't working, but the issue of credibility and saving face took precedence over, making a sound, rational decision as to whether we should continue it. And again, I think that's why we need to, figure out, are there processes or procedures we can put in place that, serve as better checks and balances. But I thank you. I yield to my friend, Mr. Cole.
Just to add on to that just quickly to make a point, it's awfully hard to cut off funding when there's American forces in the field. Just tell you, I don't care which side of the debate that you're on. It's just extremely difficult. And I think about the Vietnam era, you have to remember most American forces really weren't in the field by the time that decision was made. They were out of Vietnam. We had training missions, and we mostly were fighting an air war in the country. So really, the executive branch had extracted most of the American ground troops. So it became easier. And that's not to take anything away from what those folks did. I think they got us out of an unpopular and unwinnable war. But it's hard. First of all, I want to thank all four of you. I really did diligently read my homework assignment this weekend, and I thought there were a lot of really excellent suggestions in there, things that we can literally pick up and do legislatively. Your suggestion, Doctor, about bulking up staff is certainly one of them, or having a legal arm that's commensurate with the legal resources that we ourselves have placed and I would nominate Mr. Raskin to head that up for us. But at the head of an executive branch, that makes a lot of sense. Putting determinative time limits on emergency power so that within a few weeks the next Congress has to act to move. Those things make a lot of sense to me, and I actually think those are things when we get done with our hearings, maybe we could sit down and work on together. I'm going to pull your attention, though, to two larger trends and get your comments on them. Because when I see behavior change inside a political institution over time, it usually tells me something outside the political institution that impacts how the actors perceive themselves and what they're doing is going on. And I think about my own congressional district. I live in a district that voted for Dwight Eisenhower twice, that voted for Richard Nixon in 1960, 1968, and 1972 by ever greater margins, that voted for Ronald Reagan overwhelmingly twice and voted for George H.W. Bush twice. And in all that time, there was a Democratic congressman. They're two different figures. And only one time did their party achieve their objective. I look at it now, I will promise you this, if I didn't vote the way my constituents vote presidentially, I would not be there the next time. And in the upcoming election, as a guy that used to run politics, and this has changed dramatically in my time in political life, which began in the late 70s to now, about 95% of the people that vote for Donald Trump are going to vote Republican for Congress, and about 95% of the people who vote against the president or for the Democratic nominee are probably going to vote Democrat. That's not like any other, so this polarization inside the population really affects what happens inside the institution. And to think that politicians will ignore that for the sake of defending institutional prerogatives, I think is to be naive. They didn't have to do that in the past. Literally, the congressman, and sometimes it was more important locally than the president of the United States. We don't live in a culture where that exists any longer. In my last election, or in 2016, I happened to mention a friend of mine that Donald Trump got 66% of the vote in my district, I got 70. And he goes, I guess that means you're independent. And I said, no, if we get in a fight, I'll keep my 4 and he'll keep his 66. So that's kind of the way it works. And I see my Democratic colleagues in much the same position in their respective districts. So I'm just curious how you think these larger forces, because they're not easily correctable by tweaking institutional changes, as important and useful as I think the things you've suggested would be, how did those things get let loose to where we have that? I mean, there's an old British historian, I will tell you, we live effectively, politically, we live in a constitutional republic full of checks and balances. We operate in a parliamentary system politically, where there is a prime minister, we call him the president, and where it is very difficult for anybody of that prime minister, that president's party, to consistently vote against him. It has to be a really dramatic moment, and it's a high-risk moment politically for any time you do it on a major issue. Not very often you consistently, well, forget consistently. If it's a big issue, you can do a lot of independence, but it is very difficult. So, one, how do we get there? Two, how do you get out of there? And I'll start, since you're diligently putting your notes down as Delmonte, I'll start with you and just kind of work across.
Just make sure your mic is on.
Well, I think one of the things that's happened in the last 15 or so years is a lot of Americans just have lost faith in the electoral process in general. You add the cumulative effect of gerrymandering on behalf of both parties, the Shelby decision, Citizens United, 2 elections in the last 20 years where the winner of the popular vote didn't prevail in the Electoral College. And the impact of that is a lot of Americans have just checked out, who have lost their faith in this body, in looking after their interests. What was it, 41% of eligible voters in the last presidential election didn't vote at all. And I think that what you guys could do, perhaps, is change the tone. A lot of people feel that it's just white hot meeting white hot at all times. And in the face of that, it's exhausting and really makes people lose faith that the institutions we have can work.
Mr. Spaulding, Dr. Spaulding?
Yeah. I guess the one thing I would put out here is I think there are large numbers of people in both parties, but especially in the kind of the movement that elected the current president, and this is no comment on him or what he's up to, who are increasingly of the opinion that it's not clear who now makes the laws anymore. When you have a situation where agencies, departments, unknown people somewhere down the bowels somewhere are writing what, for all intents and purposes, are laws at numbers of many thousands versus hundred and some, and oftentimes that then gets enforced and adjudicated within the same body, and that I think that pushes a lot of people to wonder what's really going on here, and so there's a lot of frustration about that.
I want to agree very much with that, and it's actually, and one of you mentioned discussion about the REINS Act, but this idea of forcing Congress at some level in some way to either legitimize or knock out rules and regulations, I think is a really good idea. I mean, we need to put our fingerprints on the murder weapon, so to speak, one way or the other, and go from there. But a lot of times, and our leaders do this, and I don't say this critically, it's one of their jobs. You'll see leaders protect members from tough votes because they don't want to risk their majorities. And I've seen it on both sides where they might not want to vote on a war powers thing because I don't want to put my people out there and risk not just them, but also the majority itself. So, I mean, that's, again, building in institutionally things where we're forced to do exactly what you suggest. I have a lot of colleagues on both sides that like to rail against the administrative state, but they certainly wouldn't want to have to vote on all those rules and regulations because they are high-risk votes.
So
If you represent a rural district, just try voting for Waters of the U.S.
Right.
And go home and explain that to any farmer in your district. You're going to be in big trouble.
So just to finish my point, and there will be, people will like or dislike the policies. That's not my point at all. The claim of the American Constitution is consent, which means responsibility, and it's not clear who's responsible anymore. I asserted a Republican Congress to check a Democratic president, and now and vice versa. There has to be accountability. I'm not against all delegation. Some delegation is necessary to be given this scope of government. My guess is I'm open to being persuaded about these questions about how to deal with authorization of use of force. That's a problem. I mean, sunsetting. I think it's important to kind of take a step back and recognize the reality for what it is. A lot of what goes on for governing this country is not clear who's responsible for it. And that has given the executive a lot of running room that, in my opinion, they ought not to have, can be misused, and electorally they can take a lot of credit for things that they had nothing to do with. But a lot of times you guys don't have a lot to do with that either. Because a lot of the big laws that Congress passes says you shall do this, you shall do that, but the details are left to other people to do, and the executive then can step in through their political powers and appointees and direct that in a way. Laws are meant to be general laws. This is your problem. Laws have to be general laws. But the actual administering of government requires more and more and more detail. That's where the executive has an advantage, because if your reaction is, well, we need to get more detailed in our lawmaking to control all this, you're actually got to think about the extent to which you actually are granting more power to the executive, because they're the one who's going to administer it and execute those things. So I think that stepping back and looking at it in those broad terms are important. And I would say that the changes over time, again, agree or disagree with what the policies or the objectives were, just the changes over the course of the 20th century in terms of how we govern, how regulations and laws and all of that has changed the extent of how our system works. And that's the situation in which we are now operating, like the policies are not. And you as an institution are trying to get back in control of your authority, which is lawmaking. And you've got to do a lot of the kind of basic hard work of legislating in committees and whatnot. That's why, although it's not the exclusive answer, I think getting control of the budget is really important. Because historically, controlling the budget, I mean, presidents would sit in fear when Congress decided to get control of an agency and get rid of somebody, or your budget power is a strong power to get control of this whole thing.
I would tell you, before we move on, we actually have control of the discretionary budget. We're in a debate right now over coronavirus. If you looked at the Trump budget, you would have seen cuts for NIH, CDC, whatever. You look at the budget that a Republican Congress passed and a Democratic Congress now passed, CDC funding in 5 years is up 24%. NIH funding is up 39%. Strategic stockpile is up almost, again, 34, 35%. Infectious disease rapid response fund, Republican idea put in now more money in there. So actually in the budget, it works. The problem tends to be Medicare, Medicaid, Social Security, the entitlement stuff. We actually control that budget in ways, again, just look at any president's budget, President Obama, President Trump, anybody else, send it up here, and then look what's there at the end and see if they look remotely alike. They really don't. I mean, appropriators really are, I say this as one, pretty much give and take kind of politicians that find a middle or become experts in areas where they really, I think of our friends, Chairman Upton when he was chairman, and gosh, what was his counterpart on ENC? Think of 21st Century Cures, a great bipartisan, overwhelming vote that probably had more to do with medical innovation and streamlining and research than anything else. So actually that kind of stuff we do pretty
I don't disagree with that. My only point is that if you don't like something the administration is doing in terms of executing one of your policies, one of the most powerful things you can use is the phrase, Congress shall spend, no money shall be spent to do this.
Yeah, couldn't agree more. Sorry, Dr. Pearlstein?
Thank you. Backing up for a second to your question about the causes of the intense polarization I included in my testimony, and there's been some wonderful political science done that documented exactly the sense that you were describing about the polarization of your district and others across the country. That is real, and its causes are, I think, many, most of which are beyond my pay grade in the sense that, right, I'm a constitutional law professor, but I do want to flag a couple because they are potentially, at least, within Congress's ability to engage or change, right? I think one that may not fall into this category is the extent to which the existing primary system favors non-moderate members of both parties, right? So the most motivated voters come out for primaries, and that tends to favor less moderate candidates. And that's a significant problem. For this, you need an election law scholar and an election law hearing, but that's something I think we can't underestimate. Equally, money in politics is a growing problem. It's been a problem for a while, but the ability of outside groups of both sides to spend effectively unlimited amounts of money has also tended to increase polarization, right? It favors the extremes. That's where often the money comes from, and that's a problem as well. Social media requires some attention that has been not just because of outside interference, but internally becomes a sort of source of growing polarization. It makes it easier. And that's something that requires, I think, congressional attention ultimately as well. And then finally, and this gets back to more in my neck of the woods, the response in the executive branch to the reforms of the 1970s, which we talked about some, the War Powers Act, the National Emergencies Act, there were a sort of suite of legislative efforts to, in response to perceived excesses of the decades before, constrain executive power. The response within the executive branch, and in particular among executive branch legal counsel, has been to very effectively over decades develop interpretations of both the Constitution and those pieces of legislation that effectively make them toothless constraints. Now, it's not the only reason that there are toothless or less toothful constraints, but the role of the Office of Legal Counsel within the executive branch, some of my best friends are veterans of the Office of Legal Counsel, but they are executive-minded lawyers, and they're good lawyers, and Congress has no mechanism for We favor competition in every other way. No mechanism for competing regularly with respect to voicing the constitutional understanding that this is not, in fact, the power of the executive. We're not acquiescing to this assertion of authority. OLC might say it, that doesn't make it the law.
Yeah, I thought that was a great point that a number of you made. Dr. Fresh?
Representative Cole, I'm not a doctor, but my parents will be happy that I became one today.
I've just promoted you.
I think your question's very perceptive, and I too feel I'm a little, I'm not quite situated to answer it because it's not really a legal question, it's a culture question. I think the fact that there's this hearing today and that people on the committee are genuinely interested in working together and not trying to score points against one or some other president, I think is a good thing. I think when members of Congress model good behavior, people are perhaps likely to take lessons. I think of Senator McCain talking to some group where he was running for president and someone said something about Senator Obama and he chastised or kind of corrected her or him. I think that's good behavior. I think tone and you know, is important for you folks to maintain. I think this would be bad for some of you, but you know, I think the gerrymandering problem is something you can fix. You have authority to regulate federal elections. You can set districts for the states, and you can set them randomly. What happens now is, you know, that state legislatures sort of cram a bunch of Republicans or Democrats in a particular district, and that tends to make those the representatives from those districts more either right or left. And
Not to contest, but as a guy that used to do this stuff for a living, I will tell you that's lot less of a factor than most people think. I mean, my district hasn't been gerrymandered, and it's changed dramatically. You know, and in my state, every district was drawn by Democrats for 100 years. We reached the point under that system where every seat was a Republican seat in terms of the congressional delegation. So, again, I don't look, I used to practice the dark arts, so I understand, you know, trying to tilt the table around the edges. But I also know that that's not really what's driven this. I mean, I think those kind of technical solutions miss the bigger point. You know, when I first got here, all of Arkansas, except one seat, was Democratic. 3 out of 4 House members, both senators right next door to my state, they're all Republicans today. And it wouldn't matter how you drew those lines. They are very red. When I first got here, Connecticut, 3 out of the 5 members from Connecticut were Republicans. In 2002. They're all Democrats today, and you can draw the line however you want. They're going to stay Democrats. So there's something much deeper than politicians tilting the table here going on in our country broadly through the political culture. And all I'm suggesting is that manifests itself inside the institution in terms of the kind of behavior individual members follow or feel the need to follow. And I say that with no judgment on either side. I'm just telling you, anybody that's up here is pretty politically pragmatic if you're here for any length of time. So whether you're on the left or right, and so that means they're usually making pretty pragmatic political decisions, at least in terms of their individual interests. And that doesn't mean they're not capable of rising above that and thinking the greater good. I've seen a lot of instances of that on both sides of the aisle since I've been here. But practicalities will drive decisions 95% of the time. I have one other question, and if I interrupted you, I'm sorry. And it's the reverse of this problem. And this is, again, just to get your thoughts on, because you study, this is almost an inside the institution question. I will tell you, I sat for a while at Republican leadership, and during that period of time, as an elected Republican leader, basically not going to any of my committees, and I'm talking to other Republicans, and almost every meeting is about how we can beat the other guys, how we can beat them legislatively, and how we can win electorally. Every single decision. Doesn't mean policy doesn't come into it, and you're informed by your previous policy. And I suspect that's true. Matter of fact, I know that's true when I talk to my Democratic friends that occupy similar kinds of positions. The minute you become a leader at the higher levels, you're not going to committee meetings anymore. I bet you I've talked to more Democrats in a day than any member of Democratic leadership talked to Republicans in a day, and vice versa. I bet my colleagues at the committee levels talk to more Republicans by going to their committees, interchanging, interacting, maybe working on legislation. My friend Mr. Perlmutter just, brought a marijuana thing that brought, my God, Christian conservatives and, liberal California people together on the same side. I don't know how he did it, but he did it.
It might help fix the tone.
It might help fix the tone, yeah. I already think you guys are entirely too mellow. But seriously, the bigger act of bipartisanships that I see tends to be from individual members, actually operating in the milieu because they're building the relationship back. The way we operate leadership around here, they don't do that. They're not, I guarantee you, the leadership of the two parties very seldom, if ever, sits down, short of a national crisis like, TARP or something like that, and says, okay, I wonder this year, we all know our entitlement programs are out of control. Are there 2 or 3 things we could do together that we could get this, or any things like that? Or they're not having the kind of discussion we're having right now, that thanks to my friend, Chairman McGovern, where they're talking, we know we all agree the institutional powers of Congress have weakened. I guarantee you every member of Democratic and Republican leadership probably agree with that, just like every member, I think, of the body would agree with that. You think any of them are talking about how to reassert that? I'll guarantee you they're not. They're not sitting down, having read the papers you were nice enough to prepare for us, and said, well, here's 2 or 3 things that are not particularly partisan, that are institutional. If we're going to talk about bulking up our legal thing, that's not a partisan thing, that's an institutional argument. If we're going to talk about, declaring national emergencies end within 6 weeks of the next Congress, unless Congress reaffirms, or if we're going to talk about, we're going to have some congressional say over this rule-making authority that the bureaucratic state is churning out, whether it's a Democratic or Republican administration, those discussions just simply aren't happening at the highest level. So I say that both to highlight it and maybe to flag that for your consideration going forward, because we got to think in some ways that the great acts of bipartisanship don't just start in a committee like Fred Upton on 21st Century Cures, or I guarantee you my friend Rosa DeLore and I work very well together on funding for NIH and CDC and all that. We have a shared consensus about this as a national priority. We don't care what presidents say much. We're going to put more money here, and we have. And we did it under Republicans, and we've done it under Democrats, and we've done it with Democratic administrations and Republican administrations. So there's places where I see this occurring. I see it on the Armed Services Committee very regularly, very historically bipartisan committee. Yeah, they got their fights, but most of the time the bills roll out of there like 62-2 after they've gotten everything worked out. So, I don't know how mechanized, well, I just said shoot up this flare, is we got to get our leaders sitting down thinking about institutional kinds of concerns as well. It can't just be the Rules Committee. We've set up, we have a very good bipartisan committee on the modernization of Congress, but you got to get speakers and leaders and whips around the table talking about this stuff and say, well, I guess I'll just set this up and you guys go over here and kind of think about that. We're going to try and play the real game, which is getting our side back in power, or keeping our side in power, and executing the president's agenda of the party to which we belong. Anyway, if you have any thoughts on that, fine. Otherwise, I'll just turn it back to my friend, the chairman. I'm doing a lot of thinking out loud, but your papers are very provocative and helpful in that way.
Do you want to make a comment? Go ahead.
Sure. Well, it's unquestionable that the whole culture of Washington has changed dramatically in the last 50 years. It used to be common for representatives to live in Washington. That not many of them do that anymore. The dictates of having to continually raise money, not only for your own campaign, but for the party itself, create a lot of necessity for travel, for being in the home district. I think of Lyndon Johnson, who was very good friends with Senator Everett Dirksen, who would come to the White House all the time and talk about that. I don't imagine those kind of bilateral relationships, bipartisan relationships exist anymore. And I think that has just really undercut not only the willingness, but the opportunities to build the social capital that can lead to the places where compromise can be struck. I think the dramatically changed media landscape has played a huge difference as well. It would have been really difficult for a first-term representative prior to the age of cable news and the internet to just catapult to the national stage and develop a reputation that is being a rebel to the party leadership. That would have been really difficult in the age of someone like Tip O'Neill. And all of that collectively, I think, is created the opportunity where you're not governing as much as you used to because of the other dictates on your time and the travel.
Yeah, that's all, I agree with that. But I think we should put in the context of what we're talking about here. I think what you've described is itself a symptom of the general description we've already kind of laid out, which is you got to think of the politics for the moment, which I don't necessarily mean in a partisan sense, but in a grander sense. You've shifted, I think, the other things are going on as well, but the extent to which Congress was responsible for delegating these powers and doing these things, you have shifted authority to the executive branch, and you got to think about the political implications of that. The kind of the stories of the past, right? People would come to Congress because that's where the power is to get something done or prevent something or get an expense. That's not as true anymore. And largely, what do? They want to go lobby the administration because that's where the real decisions are made, which is the political balance of power has shifted. And as a result, I think that's changed how a lot of people think about their own political interests. Remember in the Federalist Papers, Madison tells us the key is to make the interest of the man, meaning you folks, connected that with the place. You have an interest in your institution, and that's key to making this work. Your example, I think, is exactly right, which is a lot of the bipartisanship is kind of personal bipartisanship. You know this person, you work out some. Rarely is there that type of bipartisanship in which the individuals, even though they disagree, think institutionally. Congress very rarely thinks as an institution. It either thinks individually as members, my own reelection, or how do I get to be president of the United States, because that's where the political power is. Or increasingly, because of that shift of power, leadership in both political parties thinks more about the more important thing is to have partisan control in order to support the executive in our party, because that's where the real authority is, as opposed to, no, whether it's a Republican or Democrat, whether it's your guy or not, you actually should have some separation there and some pushback, because that's the way you defend your institution. And Congress doesn't think that way as much anymore, because part of the political landscape, intentionally and unintentionally, has shifted the focus of politics. The Morris Finer wrote a famous book where he said, Congress is the keystone of the Washington establishment. It was back in, the early 80s or something. Right? Now I think that's no longer true anymore. I think the president, by which I would say the president / a bureaucratic state, is now the keystone of the Washington establishment.
Thank you, Mr. Chairman.
Thank you very much. Let me just say, I agree with everything Mr. Cole just said. I mean, the thing is, though, is that the tone is the tone, right? I mean, it's very difficult to change given the attitudes in the country and the media and the polarization on a lot of issues. Maybe we need to get we all need to be in intensive therapy up here to try to work some of our issues out. But but short of that, I mean, the question is, part of what we want to do here is how do we do our job, right? And not avoid doing our job because it's politically inconvenient or it's uncomfortable for us. And are there processes and procedures that we need to be put in place? We talked about the war power stuff, but I mean, national emergencies. We have national emergencies that were declared when Jimmy Carter was president of the United States that are still in place. I mean, it doesn't make any sense, right? I mean, and maybe going back to what Mr. Cole said at his opening statement, maybe there may be some areas where we can, I mean, we're not going to be able to fix everything, but maybe there may be some areas where we could actually, make some tweaks and legislative fixes that will actually, eliminate some of the stuff that I think we all can look at right now and say, this doesn't make any sense. Mr. Hastings.
Thank you very much, Mr. Chairman. And toward that end, one thing that we can do is use the subcommittees of the Rules Committee to perhaps dig into the weeds a bit more and come up with a handful of solutions. Like Mr. Cole, I read a lot of this material, and you all have done us proud with your presentations. Regrettably, everything around here is top-down. We've been here an hour and a half, and we've heard from the two top members. And that would be virtually the same thing if you were in committees. You hear them bragging about how he and Rosa DeLauro got along. Well, there's something called a manager's amendment at the end of that, and if you're a backbencher, you have hell to pay to try to get some understanding inside that particular sphere. I think what happens here and what has happened, and I'm the longest serving member on this, not this committee, but in this committee now, I'm the longest serving member. I've been here 27 years. And when I came here, it was a pleasurable place. It is no longer. And I fear that it will never be again. I served on two little committees that existed then, the Post Office Committee and the Merchant Marine Committee. Amazingly, I got more legislation done in 1993 than I have in 2019 and 20. And that was because of relationships. And yes, they did stay here, but more than stay here, they got to know each other. And what happens today is we don't get to know each other. After I was here maybe 6 years, you could just point to me somebody on the floor on either side, and I could pretty much tell you where they were from, what their committees were, and that's because we got to know each other. And that's not happening, and we are driven largely by our constituents that also cause us to have this immense polarization that is going on in this country. Mr. Spaulding, you said something that distressed me, and I promise you I'm not going to use 30 minutes, but a part of what you suggested in your original commentary was that the courts are not going to solve our problems. While I tend to agree, it's distressing. You went further in a second portion to say that the courts generally are going to side with the administration, and that doesn't mean this administration, that means any administration. And I've seen evidence of that, as have you. But I think those Article 3 judges have a specific role to play. And just in those two little committees that I served, I could write a letter, and less than a month, I would hear from the bureaucracy. I can get 100 members to write a letter now, and I'll be damned if we'll hear from the bureaucracy. Not this administration. Let me criticize everyone before this administration, including we've spent a lot of time here on the War Powers Act. I criticized Barack Obama actively about Libya and the War Powers Act, and push back real quick and I'll stop. All this business about Congress doesn't have the time to declare war. How did Franklin Roosevelt get those members to declare war in the Second World War? They didn't have no damn internet. You understand? They didn't have no airplanes that flew fast. But they managed to get back here and to declare war. And that's our responsibility. And I don't care. I don't want to take away the president's powers to go forward and to do whatever he or she feels is necessary to defend the United States of America. I want to collaborate with that president. I want to have a clear understanding about why we are doing what we are doing. I'll leave it at that because there are so many members, and if you all don't mind, I'll go offline and write a few questions to you. But remember, we would be well advised, those of us here, not only to hear your words, but to remember that although we may be of a particular philosophy, ideology, persuasion, and parties, we are also stewards of this institution. And we owe it to those who come after us to leave it as strong as it can be so it may best serve the American people. And Dr. Perstein, I had originally wanted to talk with you about something Mr. Woodall and others and I have spent a lot of time on. One more vignette from my history. I went to very segregated schools, very. And by that I mean I rode 30 miles each way to go to high school, past 3 white high schools. I got to a high school that did not have a library, did not teach foreign languages, did not teach geometry, and somehow or another, the elementary school I went to was 4 grades. But you know what? I knew who the governor was. I knew who the congressperson was. I knew who the superintendent of schools were. I damn sure knew who the sheriff was. And all things considered, they were doing a better job of teaching civics, even though they didn't deliver newspapers to our area of the town. The teachers would somehow or another cut out old newspaper articles and bring them in, and we would have civics lessons. I maintain that something has gone awry in this country when it is that 1/3, as you said, of high school or college students don't understand the dynamics of separation of powers. Thank you very much, Mr. Chairman.
Dr. Burgess.
Thank you, and thanks to our witness panel for being here today. A rare moment, I find myself in agreement with Mr. Hastings about the teaching of civics. And
You ought to try it, it doesn't hurt.
yeah, it does. Yeah, it does. Let me correct you on that. But, and I also agree with Mr. Cole about the fingerprints being on the weapon. I just disagree that it's maybe a weapon to inflict a self-inflicted injury, not an injury on someone else. And I have not spent nearly the amount of time here in Congress that other people have, but just my observation is the erosion of Article I powers is something that happens gradually. It has, sometimes we see rather pronounced demonstrations. Chairman McGovern and I last night had a little discussion and disagreement about this supplemental bill that's going to go to the floor under suspension. Yes, coronavirus is an emergency. Emergency was declared in January. The Secretary of Health and Human Services enacted a travel ban at the end of January. We spent the entire month of February in one of the committees of jurisdiction that I also sit on, the Energy and Commerce Committee, and did not have really a single hearing. We added about an hour onto a budgetary hearing right at the end of February. But we're the committee that's supposed to get the data. We're the subject matter experts. We're supposed to interview the people from the administration and come up with the information to help our friends on the appropriations side come up with the correct answers and the correct funding for those answers. But, you know, real time, real world, we've given that up in this crisis. And this generally does happen at the time of a crisis. It's not the first time this happened. I probably predict it will not be the last time it's going to happen, but every time we allow that as the United States House of Representatives, we lose something in the translation. And there was a lot of criticism when Secretary Azar came to our committee last week. And again, he was there for a budget hearing, which I was grateful for. We need to speak to our agency heads about their budget. And then right at the end of it, he had the hour of coronavirus discussion. There's a lot of criticism for the administration's budget that was produced. Mr. Cole's already referenced there were some cuts in CDC, some cuts in NIH. Well, that was the president's budget. Yes, it was prepared in December before we knew what was happening in January. So, yeah, you do have to make adjustments as the world changes, and it can change quickly, as we all know. But we can't complain about the president's budget when we don't do a budget. And we're not doing a budget this year. take some exception of what my friend from Oklahoma said. It's not a budget, it's an appropriations agreement that we're coming to. It's a spending agreement, but it's not based upon a budget. I actually believe we should do a budget, and we should budget for emergencies because we always seem to have an emergency every damn year. But we're not doing a budget. I don't see that we have the bandwidth to criticize the administration for getting their budget wrong in December before they knew that this crisis was going to happen. They propose, we dispose. We're the ones who are supposed to control those budgetary pens and write that budgetary agreement. So I realize that's more of a statement than a question. I'll be interested to hear if anyone has any comment on that. Also, just on the subject of the budget, I'm sure Mr. Woodall will do a much better job if he's not already done so. Mr. Cole already alluded to the 2/3 of the budget that we no longer control in the appropriations process. And again, that didn't happen overnight. It's happened little bit by little bit. I think that needs to be reversed. I agree with Mr. Cole. Those would be very, very hard votes. They would probably be career-ending votes for some members, but honestly, that's what we're supposed to do, make those tough votes and be held accountable. And if we're not representing the folks back home, they'll get a better idea about who can. But I recognize how hard it would be to reclaim all 2/3 of that budget, but I would welcome anyone's advice or suggestion to begin to bend that curve back a little bit and bring that power back into the legislative branch where it belongs. All kinds of mandatory spending out there. Yes, there are places, I think, where we should perhaps think about bringing some of those programs back on budget. And I realize the reason they've gone off budget is because no one wants to touch that. Well, that's like the third rail of politics. You touch it, you die. But we need to do it for the sake of the generations who are yet to follow us. And again, I realize this has all been more of a rant than a question, but I'll be happy to get your input on any of those observations. I guess we start at this end this time and go that way since Mr. Cole went the other direction.
Well, thank you, Congressman. I too share the concern that 2/3 of the budget is on autopilot and never voted upon by Congress, because that obviously leads to a situation where some things are never reconsidered or relooked at because they're seen as sacrosanct. I wasn't prepared to talk about the budget process or the lack of a budget process for the entitlements, but my recollection is that Ronald Reagan got together with Democrats in the House and passed the Social Security Reform Act, and I think it's possible. I was hopeful that President Obama, he had a commission that was headed by Bowles and Simpson, and I was hopeful something would come of that. I think that's what needs to happen in order for people to have cover to do something that would otherwise be super politically unpalatable. I think you're right that it would cause a lot of people would try to exploit the situation, saying you voted to cut this or that, but it's sort of irresponsible to just spend money without thought for decades upon decades.
Thank you. I guess I'd like to respond generally to the concerns that I think both you and Mr. Cole expressed, because I think they're related. How do you carve out in a highly polarized political environment space for serious conversations that are politically difficult and in many respects politically impossible in different ways? Congress used to do a better job at creating bipartisan spaces. And you can call these, if you were in any other organization, institution building spaces, right? But Congress did this through, for example, creating bipartisan commissions, right? It's done that in the past on immigration and after 9/11 and in many other circumstances. And these commissions, for some reason, have gotten a bad reputation as never quite producing the results that they want, but they sometimes do produce results, and they certainly produce results more often than not having them produces results. So those kinds of commissions, Congress having its own agreed-upon source, CRS is a great example, GAO historically has been a great example, as our world becomes technically increasingly complicated, and congressional agency like OTA, it doesn't have to be the Office of Technology Assessment, it can be a new and better version of the Office of Technology Assessment, but something that enables Congress to have at its own bipartisan disposal its own agreed upon set of facts and understandings about how social media might be effectively regulated, why the problem of emerging infectious diseases gets worse, what we can anticipate for growing healthcare costs as the population ages over years. These are all problems that require not only the ability to meet together across bipartisan spaces and times, but also having an agreed upon set of information. And we are, as a society, at a point where even that is becoming difficult. Congress is in a wonderful position to recreate some of those spaces. And while one might be limited to 1/3 of the federal budget, that is an enormous amount of money. OTA, when it was zeroed out, had an annual budget of what, $20, $30 million a year, right? So that's a lot of money to me, but I don't think it's all that much money to you guys. So I guess I talked about some of this in my written testimony. I think those organizations are important and useful not only because they serve an educational and information generating function, but because they also make it possible for you to begin to remember or regenerate those muscles of working together institutionally that have atrophied over recent decades.
No, I agree with the concern you've raised, and I guess I would premise it by saying it's often the case, among others who have suggested reforms in the past, we're always looking for technical fixes. People always want to find the silver bullet. And I guess if there's a theme here, my theme is, no, it's actually the hard work of governing that needs to be reestablished. And the fact that 2/3 of the spending is automatic, there's still a third, but it really is the principle of the matter. You guys are the legislative branch, and that's your responsibility. My point is I don't disagree with Congressman Hastings' point. My point was not to neglect using the courts. The courts are there for a purpose. It's just that as an institution, I'm more interested in seeing you act institutionally as opposed to running to the courts. Same thing I told the Republican Congress when they wanted to do that, when they had the majority. You want to be institutionally stronger, it seems to me. And the other general point I would make is that I am struck by how important commissions are, but the question is, how do you structure them? I think one of the most successful ones that solved a problem was the BRAC Commission, right? You had to shut down a bunch of stuff, and no one wanted to do this because it's in my district. So you figure out a commission to do it, and you kind of all do it together. Maybe there's something like this here. I'm not sure it's a particular piece of legislation. I mean, doing it, yeah, you're going into election where it's not sure who's going to win, but you're in an election cycle. You need to do something where you figure out what the pieces are. There are going to be trade-offs. We're going to reduce this power. That might be what the Republicans want. And in exchange, we're going to reduce this power with the Democrats. There's going to be some sort of balance there. But then you could have it not engage until not this next president, but maybe the president after that. It could be something in the future. It's got to be a bipartisan reform. I think it's got to start by reestablishing the premise of these things. You can't bite it all off in one thing because it would be suicidal in most cases to do so. But I mean, take the 2/3 of the budget that aren't that are automatic. Well, you might keep that going, but at least if you take the act of voting on a regular, you get into the habit of it. And those kind of things I think are actually quite useful.
I think that in addition to the tone, the context, all of this is happening really matters a lot as well. For millions of people in the United States, the promises of globalization just haven't worked out. The decline of American manufacturing, the winnowing out of many communities that had a local employer on which many people depended that's no longer there, opioid crisis. And we're watching our country shift dramatically, an aging population, the decline of a college-age portion of our population, There are so many things converging, and it just amplifies that sense of helplessness and hoping that you will take those hard decisions on that 70% of the budget that is mandatory spending. As we watch income inequality just continue to exacerbate, we have a distressingly large number of Americans who can't handle an unexpected $400 expense. And so a sense of desperation rises in diseases of despair. I just hope that we can make those hard decisions, because the fate of our country is hinging on what 535 people in this body do.
I just have one further observation, Chairman. I am fortunate to serve on the Committee on Energy and Commerce. We, over the past 5-7 years, have passed several landmark bills, the track and trace bill to secure the safety of our pharmaceuticals in this country. Certainly Cures for the 21st Century is one of those big bills. A year ago, we passed something dealing with opiates called the Support Act. Several years before that, we repealed the Sustainable Growth Rate formula and the follow-on from that. The one thing I've learned from passing those large landmark pieces of legislation is it doesn't end at the signing ceremony. You've got to watch it like a hawk over at the agency. If you don't do it, I'd even hesitate to call them oversight hearings. They're implementation hearings. Has it been implemented according to congressional direction, or has there been some interpretation? And I could cite you numerous examples, but I won't. But it is a constant feature of at least our job when we write those authorization bills in the committee, the other committee that I'm fortunate enough to be on. When we write those legislative treatises, we need to have the courage to follow them through. We all have busy schedules. There's never enough time in the calendar. There are never enough hearing rooms, but we need to make it a priority and make sure that we do it. With that, I'll yield back.
Thank you, Mr. Perlmutter.
Thank you. Just a lot of thoughts, starting with ambition. And I think each of you mentioned Madison and ambition, and that would be sort of a limiting factor to the loss of power. The other sort of contrary philosophy out there is the path of least resistance. And those two, path of least resistance has been winning. And honestly, I want to thank Mr. McGovern and Mr. Cole, because I think today is going to be the last day that the path of least resistance wins automatically. I'll give a quick story. There are a lot of people that have questions, but my backyard, I have two backyard neighbors. One a very conservative family, another pretty liberal. And a few years ago, I'm cleaning up in the backyard, and the gal, a pretty conservative gal, comes up to me, and she goes, "I can't believe Obama has 212 emergency actions." I went, "What? What are you talking about?" He has brought forth 212 rules or something based on emergencies. I said, "Well, that can't be true." And I kind of stepped back, and he had done a lot of emergency things, starting with DACA and a bunch of other stuff. Well, about 3 months ago, I'm in the backyard, the other side, the liberal guy, he says, "That Trump, he's doing, everything he does is based on an emergency. There aren't that many emergencies." And, that's sort of what's been going on here. We've allowed the power to move to the executive branch. And Dr. Spalding, I couldn't agree with you more. The administrative branch just keeps growing, and your comments about policy reformers, I went back, I was looking at everybody's slogan, "Make America Great Again," or "Obama for Change," or, whatever it might be. I mean, back long ago was "the buck stops here," or "I like Ike." But now it's about some sort of change in policy, and people look at it that way. So I think, and Mr. Cole kind of let his hair down. I mean, part of the problem here is we've got to be intentional in resisting this, let's let them do it. Let's forget about, we'll give them really broad discretion and just let it go. We'll move on. We've got to be intentional, and we got to have some intestinal fortitude, because there will be some prices to pay. So I guess I'd just like to ask the panel, we're dealing with coronavirus right now, emergency setting. And I think that's one we could all agree is it's an emergency setting. How far it spreads and how quickly it continues to spread, obviously we need to address it. So as our appropriators, Mr. Cole and Ms. DeLauro and others are putting this piece of legislation together, how, as historians and constitutional experts, should we limit this so that we don't, again, just give something away like we gave away earmarks or we gave away the emergency powers? And how, in that context, would you help us, as quick as you can, because I want to turn it over to everybody else, kind of limit this legislation we've got before us as a turning point where, okay, we recognize the emergency, but we're not going to just give you the keys to the car for the rest of time. Professor.
Well, Congressman, that's a very tough question. I don't really know anything about coronavirus other than what I've read.
But from just a legal drafting standpoint, I guess is what I'm asking you.
Let me just throw out some ideas. I mean, it's possible that you pass an appropriation, but you don't make it large enough, or you make it small enough that they have to come back in a month and update you with what's going on. And maybe that's how you keep the keys to the kingdom. I don't, my sense of appropriations is there's lump sums, and then the authorizers are supposed to tell them what to do with it. I don't know if that's happening here or what's going on. But if you have a sense that they're giving away the keys to the kingdom, there's clearly something wrong with the bill that's before you.
Like any good lawyer, really reluctant to comment on legislation I haven't seen.
Just from a legal writing standpoint.
So let me say three things about very broadly, about how Congress should think about its role as legislators, right? It has every bill, you have 3 moments of asserting your views and regulating effectively. One is in directing the executive or whoever it is, HHS, CDC, whoever, right? Directing them specifically what you want to do. You want to say regulate in emergencies? Fine. What do you mean emergency? Do you mean something that is stuff that happens every day or that is likely to recur repeatedly? Or do you mean something, for example, that's time limited, right? Something that a reasonable scientist or officer of the CDC would expect would not recur or would last for a limited period of time, right? So there's a lot to be done with drafting. You can condition funding. If condition X doesn't occur, right, then these funds aren't available. If condition X occurs, then these funds become available. So that's just at the direction stage, right? Then you have options when legislating in the first place for imposing monitoring, right? And that can be come and testify, but it can also be you shall every 15 days or 30 days or whatever it is, report, and that report shall be detailed, and that report shall include the guidance of whichever relevant experts you want to hear from, and that report shall, for example, be certified by Dr. Fauci or whoever else you want to make sure is engaged in that process. And you can have requirements of consultation with Congress, requirements of consultation. You can build in monitoring in lots of different ways, right? And the third kind of thing you should look at every piece of legislation to make sure it has is some sort of termination or calendar. And by which I don't mean these funds run out on May 1 necessarily, right? But which leaves Congress holding the key to say this runs out after, pick your date, right? 90 days, after which time Congress must reauthorize, or after which time, whatever. So all 3 of those things are options for ways that Congress keep holding the keys.
Perfect. Dr. Spalding, I would say, I wanted to say one thing to you. I mean, I think you're absolutely right. The power of the purse is the ultimate power. This committee, last year when we were in shutdown, we would meet about every 2 days, hoping that there would be some compromise that would allow us to open the government again. I mean, that is a blunderbuss, big-time hammer to use, and not one that we want to use very often. But to my question.
So I don't at all disagree with the points that are made. Those are well said. And I'll actually make a non-budgetary answer partially, which is, look, you're going to the authority here is you're going to use your power of the purse. And the president is in a position where he needs you to use the power of the purse, which means you have what we call leverage. Congress should declare a national emergency. Who says only the executive can declare national emergencies?
Hear that, Mr. Cole?
And
You might
you
put that in the bill as you guys draft
so
it today.
if you object to him, the executive having that power, why don't you do it and preempt him?
He's drafting this bill today, so that's why I'm...
And then all of a sudden you have both branches defining what national emergencies are,
Thank
and
you.
you've got a conversation,
All right.
and you've got leverage because it's a must-sign piece of legislation because it's got budgetary authority behind it.
Thank you.
That's an example of exerting the spending power.
Thank you very much.
I have nothing to add.
All right, thank you, and
Thank you. Mr. Woodall.
Thank you, Mr. Chairman, and thank you for holding the hearing. Thank you all for being here. I'm trying to think about that pathway back from here. We talk a lot about small ball versus big ball here, and I think a lot of our challenges is just bad habits. I'm thinking about the list of things that you just gave, Mr. Perlmutter, for example, those oversight-related items. Well, I put all sorts of conditions in bills, but very rarely do I come back and enforce those conditions as Congress. If anything, I'm going to go file suit, and I'm going to ask Article 3 to enforce those conditions. And so there are many things that we could do that will not only accentuate our the feckless Congress of today, but will further weaken us tomorrow. So what do you see as the pathway back, those incremental steps? You mentioned it, Professor Prakash, that we should play to our strengths, right? There are those things that are not naturally divisive, but we've just gotten into bad habits. Appropriations bills, right? It used to be unthinkable that you could get to September 30th and have not worked on the appropriations bills. Now it's probably more unthinkable that you're really going to make time to work on the appropriations bills at all. You'll just pass an omnibus on September 30th, and that just took 2 decades to take hold. So help me with those beginning steps back. I know you're not behavioral specialists. You're constitutional specialists, but because you've seen the pendulum swing over the decades, help me with that.
Congressman, I think that's a wonderful question, and as you said, I'm certainly not a behavioralist. I wonder if members of Congress are conscious of the time they spent doing various activities and then thinking about how they ought to reallocate it in a way that makes it more possible for them to conduct legislative business as opposed to the myriad of other things they have to do. And I think, if you don't do that, you don't have a sense of what you're doing with your day. I think, speaking for myself, I sometimes get a message on my phone, you were on the phone, an extra 5 hours this week or something, or you played this game for an hour. And those things add up. And so maybe that's a small ball reform that would conserve your time to do things that you think are more important, like legislation.
I serve on the Modernization Committee that's looking at some of those items, and what we found is the best way to do that is to get folks to focus on things. I just had to come from another hearing to be in this hearing, but guess what? That was transportation, and I don't want to give up the Transportation Committee, and I don't want to give up the Budget Committee, and I don't want to give up the Modernization Committee or the Rules Committee either. And so here we are. My bosses back home encouraged me to do more things less well instead of a single thing well. But I appreciate that the targeting is absolutely something that we're trying to sort through. Does anybody else have any wisdom on the steps back?
Thank you. No, I think you're right in terms of thinking that through broad stages. It's probably impossible to identify them in particular ways. But I would say there are at least 3 phases. Again, putting it in broad terms. One is, the first phase is just kind of having the will to do it. Congress speaks as an institution through its legislative function, and I believe it's actually the most powerful of the 3 branches. But it needs to talk that way and act that way. So I think part of it is just establishing the will. So that's my psychological answer, I suppose. But then I would make a distinction, which is, I made the point, you play to your strength. The place to start is where you're strong, which is why I've emphasized the budget power. And then once you reestablish that strength, you want to use that strength to exert yourself in other areas. Now, that's not to say you don't fight those other fights if they come along, as you should. But you should have that in mind, which means you're really kind of taking the steps to rebuild that strength. And there, I think you're right. Budgeting is the key power. I mean, I've always wondered why there are a certain number of appropriations committees, or why you have to do it in a particular order, right? I mean, these are all political questions, and the number of committees is based on the number of divisions within the budget that comes from the president. You could do your ordering of your appropriations differently. You could get the easy things off the table, or save the things you want to have your most leverage over till later. I mean, just think strategically about where your strength is and how to use that as powerfully as you possibly can. And I would start there, and then let the other things, as they come up, fight those when they need to come up. If you need to have a fight over an authorization, I'm not opposed to those at all. But I think this is a long-term problem, and part of the long-term solution is rebuilding your strength.
Dean?
I would echo a lot of that. I've thought a few times this morning about the famous warning in Dwight Eisenhower's farewell address in 1960 about the military-industrial complex. And that's something that's happened to decrease your power as well. There's a whole lot of special interests that are continually bombarding the government, and maybe considering how some of that might be reined in would be really beneficial here. Others have mentioned increasing your staff. They're facing a whole host of actors that are trying to make government work on their behalf, and the administrative state as well. Empowering and growing the Congressional Research Service, which used to really provide an excellent source of impartial information. And we're in an age where we have more information at our disposal than ever, and probably no less than ever as a result of it, because it's gotten so difficult to discern what is or is not credible. There are some proposals about increasing the size of the House itself, so people can be more responsive to their constituents. That ratio has changed dramatically. Thinking through inefficiencies in government, the CERT process, the length of time people wait for clearance, inefficiencies in procurement that leave government behind private industry and the type of technology it can use, the purchasing process. And then I would repeat the suggestion of an Office of Legal Counsel within the legislative branch.
Well, we certainly did that with the Budget Act and CBO, right? We were tired of getting pushed around by OMB, so we created CBO and did a pretty good job. Now, I would say the American people don't rely on OMB for their budget information. They trust CBO instead, and we achieved exactly the goal that we desired.
Right. I should have added, I actually agree with the notion that Congress needs to beef up its ability to do things. One of the mistakes of the contract with America, and if you ask Newt Gingrich, he probably would agree with you, is he took the first step of, since he was in favor of cutting government, let's unilaterally cut ourselves and reduce our size. And that was a big mistake if you want to be a player in the game. So I would agree with the sentiment that others.
Well, of course, that hammered the House even more than it hammered the Senate, because we were driving that train, whether it was 1994 or 2010 when I was elected. Those were our two big Article I budget cutting years, and particularly House budget cutting years. So let me ask that question pointedly to you, since it's not a partisan panel. We all want to serve our bosses well, and generally, serving the Constitution trumps every other concern that my constituency has. If I was to paraphrase you, Dr. Spaulding, I would say that you are telling me that I am betraying rather than serving my constitutional responsibilities by shrinking Article I spending relative to Article II spending. Is it that simplistic that you believe that our constitutional obligations are being subjugated to our budget concerns?
I think your obligations, first of all, your first obligation is to the Constitution to which you swear allegiance, but you're a congressman, and your obligation is to this institution and its powers in Article I. You think that you have powers. You have no specific constitutional powers individually. You only have powers as a body. You have those obligations to not only exercise, but keep an eye on and monitor the powers you have been given responsibility for. So let me answer it this way. So one of the tendencies that has happened over time, again, like the policies or not, is that we have more and more put kind of experts or bureaucrats or administrators, use positive or negative connotated language, but they're out there. In an odd way, I'm actually advocating more politics, not less. That's the Madisonian solution. The Madisonian solution is that the branches need to compete with each other and be strong enough to engage each other. The problem is a lot of the expertise that makes the kinds of decisions you guys ought to have responsibility or has been sent over elsewhere. And having done that, you've weakened yourself to play in the separation of powers back and forth. That's the mistake. And so what is your answer? Well, sometimes you do have to delegate, and these things are complicated, and you want people that know particulars, and so you set up these. I'm not saying they're all, but you need to recognize what that means constitutionally and politically in terms of you carrying out your constitutional duties and responsibilities. And I think that over time has become a real problem from both points of view of both political parties. And you've also fueled the ability of the executive, who has nominal control almost all of that, to figure out ways to creatively use all these regulatory authorities, sometimes poorly written laws, sometimes laws that contradict each other, in ways that allow them to essentially govern. And so, yes, I think that institutionally Congress is not upholding what I think is its primary constitutional obligations.
Professor Pearlstein?
Thank you. We agree on quite a bit, and indeed exactly what I was thinking as you were asking your question was about Congress disabling its ability to compete effectively among the branches, right? So if the idea is ambition will counteract ambition, part of the ambition has to come from individual incentives, and that's a big problem. And we talked about politics and polarization a little bit earlier. But the other part of that is simply resources and capacity. And you are now completely beholden to and dependent on your supply chain for information, which comes almost entirely from the executive branch. So that's putting yourselves in a place where you can effectively institutionally compete is essential. There's one other piece of this I wanted to point to, and that is, as you think about the separation of powers and your ability to compete across three branches, there are three branches, right? So it's not a two-way game, it's a three-way game. And one of the large problems that's contributing to the overwhelming effectiveness of the executive in winning this contest, so to speak, is that both of the other two branches are in one way or another shirking. And that sounds like a bad word. I don't necessarily mean it that way, but right, Congress delegates its power to the executive acts, and the courts say, we need to defer to the executive as well because that's the source of expertise, or because, well, the executive knows more about foreign policy than we do, or because, as a decision in this past week says, I'm not sure members of Congress have standing to sue in courts to enforce, right, the powers that they're trying to enforce. Now, obviously, you don't want to interfere with the exercise of Article III courts' ability to exercise independent judicial judgment, but when Congress does things like legislate to create a cause of action, right, pass a statute that includes a right to sue, this sends to courts a message that says, in fact, we don't want you to shirk, we want you to be as engaged as we are, right? And the notion is, by adding powers, not just saying, well, you take the ball, right? By adding powers, you better empower both branches to fight the executive.
Let me follow up on something you were saying to Mr. Perlmutter. Again, some of those things we could do to hold folks accountable. I think that our work here is a little like parenting. It's important to set boundaries, but the worst thing you can do is set boundaries that you're not going to pay any attention to. So back when we used to do appropriations bills regularly, you'd get to the end of the appropriations bill, because we're reading it line by line, we start going through all the reports that are going to be required, and they're going to be, you're going to do a 7,000-page report on how to solve world peace, and it will be due by next Thursday, right? And there's no expectation that we're going to get that done, and they're going to ignore it, and we're not going to enforce it. Thinking about that give and take, maybe it's hard for us to reclaim some of that power. It should be easier for us to stop giving away any more power. Tell me about the interplay between your encouragement to hold folks accountable versus the parliamentary system we've fallen into, where folks don't want to embarrass their president. And in fact, my bosses back home don't want me to embarrass their president, depending on where those political winds are blowing.
Sure. So a lot of different things to say there, but let me maybe highlight one or two. On the question of what do you do when the executive doesn't do what you told the executive to do, right? Whether it's filing reports, the statement of legal theories as changed under the existing authorization for the use of AOMF as required under the National Defense Authorization Act that was just passed was due over the weekend or at latest, I suppose, Monday. It has not been received, right? So that's a big report. We haven't seen it yet unless something has happened while we've been sitting here. So there are a couple of ways to deal with situations like that. One is you create incentives in the individuals who serve in the executive branch. Now, the extreme way of doing that is by imposing particular kinds of liability, but Congress has done that before with its assertions, the Anti-Deficiency Act and the Impoundment Control Act, right? Trying to make sure that individuals within the executive branch have personal, professional incentives to do what Congress has said the law is and not to follow an executive who says otherwise, or right, in order to follow Congress's priorities and not someone else's. But I don't think you have to necessarily start with the nuclear option, that is necessarily start with the individual liability members of the executive branch option. I think there are other steps that you can take short of that, including using the budgetary power, which I entirely support. The funding simply stops if this is not forthcoming. Congress has to exercise some judgment. Which are the reports that are really important? Which are the reports that aren't important, right? Because even within the executive, there are only so many hours in a day. But there are, as with these other kinds of ways of drafting legislation, a menu of options. And rather than thinking about enforcement as an on-off switch, think about it as a continuum. The sort of heavy guns of enforcement are individual liabilities or fines, for example, if this doesn't happen. Less than that are simply a right to sue, right? Less than that is something like a funding cutoff or a warning. Less than that is sort of the basic oversight functions. When this report is due, this official is required to come testify. So the official who's responsible for the report, the Secretary of Defense or whoever it is, right, has to show up and personally take responsibility to Congress if the report is not brought with him on the day of the testimony, right? So there is a menu of options, and Congress has all of those powers to sort of design them as it wishes. It depends, in emergency powers and emergency situations, you want to design that menu somewhat differently, but all of those tools are available, and I think should be used more liberally than they have been, liberal with a little L.
Okay. Dr. Spaulding.
One thing I would add to that is, look, one of the dilemmas I think both parties faces is what you alluded to at the end. How do you carry out your responsibility when the person in the executive office is of your same party and you don't want to embarrass them, and your constituents don't want either? That's a problem. Part of that, I think, part of that answer is, I don't mean this in the downplaying sense, but in the powerful sense, a rhetorical answer. When I said earlier about establishing the will to act as an institution and your responsibilities, Congress needs to talk that way more. So, yes, I'm sorry, Mr. President, but it's not that I'm against you. I like what you're doing, but it's my obligation to make sure this is done correctly and through a particular process. I think that, Congress is timid when it comes to those things because we've gotten to a point where everyone assumes that as soon as you draw a line, it means the nuclear option, or it's a red line, right? I mean, one of the reasons why I think we want to, from a constitutional point of view, push more and more authority back into the legislature is precisely because the legislature is a place where you can have deliberation and consensus and accommodation, right? The problem, I'm not opposed to going to the courts, but I generally don't like the courts in political questions because they're binary. The reason it's a problem with the executive oftentimes is because it's a unitary decision, right? Congress is the body, the branch in which you have to figure out how to come to some sort of accommodation on those things. But you need to explain that to the other branches in a way that defends this despite your partisan affiliations with or without the executive. Not every challenge of a president is partisan. They shouldn't be at a certain level. There are certain things, I mean, I'm not naive in the sense we're not going to have partisan challenges, but they're institutional challenges. And you should be at the point where you can do that with a Republican or a Democrat, given the control of Congress being the other way around. And today, everything you do, every motion, every little gesture is seen in partisan terms. Part of that, I think, is also learning how to better explain and argue those things in public terms through legislation, but also in terms of how you talk about these things.
Professor Prakash?
I mean, I think the way I would try to explain it to a constituent is it's not about this president. What we're doing is constraining the presidency writ large, and it applies to this president or President Sanders or President Warren or whoever might come down the line. And so I think putting it that way makes it clear to people that since they don't have a monopoly on the presidency, they can see the wisdom of the institutional constraint without regard to who is president. And, you know, you can even tell the president it's not about you, right? Maybe this takes effect next year, right? And so, you know, or whatever, 3 or 4 years from now. And it's not as good as it taking effect now, but it's certainly, you know, since people don't know who's going to be the next president or even the next president after that, I think it's easy to say it's not about any particular person.
Please.
Well, I mean, correct me if I'm wrong, but I believe if Congress votes a pay raise, it doesn't take place until after the next election. Something like that ought to be your model, to make it very clear it has nothing to do with the current occupant of the White House.
Though to the point of what we're talking about, that's exactly what the 27th Amendment says, and yet in the middle of every congressional session, we go to the law and we change the law that provides for that across the board cost of living increase for federal employees and say this shall not apply to Congress. There's a constitutional amendment that says you can't change pay in the middle of a term, and yet we do it every single term. Strangely, there's no special interest group litigating that or trying to get that fixed. Two quick questions, Mr. Chairman, with your indulgence. Sunset language doesn't exist very often. When things do sunset, oftentimes we don't go back and reauthorize anyway. From an institutional perspective, creating more sunset language strengthens us as Article 1, or because of our habit of ignoring unauthorized programs and their expiration continues to weaken us as Article 1. Is it obvious to you?
I think you hit on a possible dilemma. On the one hand, for a lot of things we're talking about, I actually like sunsets, right? I mean, you authorized a certain period of time, there's going to be an authorization for a military act. Having that sunset or defining it is a great idea. But like you said, this is an exercise in parenting. You got to enforce your sunsets. And there are plenty of programs that have long sunsetted, but you still appropriate money for. And there's all sorts of contradictions out there. So whatever you choose to do, I think one of the things that will play to your strength is being consistent.
Professor Prakash?
So with respect to sunsets, I think they are essential for use of force measures in particular, and emergency authorities in particular, because the way the legislation and authorities are currently designed, it requires a supermajority. It is a simple majority of Congress to flip the switch on to war or emergency authorities, but it requires a supermajority of Congress to turn it off, right? And that's because of CHATA, and you can't have a concurrent resolution. We talked about this a bit earlier. It's in my testimony as well. So there, a sunset is, I think, indispensable. Beyond that, and beyond that context, I think the way to think about sunsets is not necessarily as does it increase or decrease power, but about what kind of incentives it gives you to vote or not. Sunsets are what I would call a democracy-forcing device, right? They don't empower or disempower, they just make you vote again if you want to take action. So if it's something that you think is essential for there to be repeated democratic consultation on, a sunset is a good thing because it will make you vote. If it's the kind of issue that you think, nobody's going to want to vote on this ever again, then you want to be maybe more cautious about sunsets because you will come to the requirement of voting, and if your members you think are incapable of acting for political reasons or whatever else, and it's something that's important, like CDC funding or whatever else, then you want to be more cautious.
Let me ask when the golden age of Article 1 empowerment was. You don't have time today to tell me everything that we need to do to get right, but I can go and read the history books and see what folks were doing right. One of my favorite quotes is that Jefferson letter to Rutledge in 1797, and he says to Mr. Rutledge, "You and I have seen warm debate and high political passions, but gentlemen of different politics would speak to each other. It is not so now. Men who have been intimate all their lives cross the street to avoid meeting and turn their heads the other way lest they should be obliged to touch their hat." Right, this was 10 years in, and we'd already gone to pot. And presumptively, those political passions in the Senate bled over into Article 1, exercising oversight of Article 2. So if we'd already come unglued 10 years in, what are you going to point me to as that error? Right, we've got more vetoes, I think, in the few years of the Ford administration than any other presidential administration, as America was reacting to executive power and a pretty high supermajority in the legislature. But where's the? It's so easy to say today is bad. I want to know when it was good, and that'll help me to plot a course.
Congressman, it was never good.
Okay.
I think part of it is that, there was never intended to be a golden age, right? The whole point of the Constitution, the beauty of the Constitution, seen in the Convention, the Federalist Papers, is a recognition that the nature of man is full of political passions and interests, and a lot of good, too. But government's job is not to figure a lot of that out, but to create a structure by which we can exercise the powers that need to be exercised, be able to have an executive that needs to, what we need for crises and necessity, and introduce this idea of a court system. But they were never naive to think that somehow this is a perfect, and the actors would be perfect, right? What they recognize, which is why I think our obligation is to the Constitution, is precisely that all the actors in the government are going to have some political instincts. It's human nature. So instead of forgetting that and ignoring that, which is one of the reasons why I'm a little bit more nervous about political power being exercised by people not clearly under the legislative or the executive power, right? They're political too. They were not naive to get rid of that. So instead, let's give them a political interest in their institutions and then set the institutions against each other through the separation of powers and checks and balances that then give rise to a higher obligation to uphold the constitutional system. The break, in my opinion, occurs once that system starts getting mucked around with over the course of time. I've identified it. It's hard to identify a particular point, but kind of with the shifts towards this different way of thinking and introducing arguments about more administration, which feeds the executive branch, and then once you centralize in the 60s and the 70s, again, like it or not, that creates just the sheer amount of activity that I think makes it virtually impossible for Congress to exercise its true legislative powers, and they've gone to the methods of least resistance, and the executive now can exercise more power because if you guys have not as much ambition, I can tell you, executives tend to have more and more ambition. And that's the root of our problem, I suppose.
Dr. Spalding tells me it's never been good. Surely someone else can lift me up more than
It's
more
been
than
better,
that.
though. It's been better, though.
I'm afraid I would agree with that. I mean, let's not forget that it was at this very building where Preston Brooks beat Charles Sumner with a gutta-perch cane senseless.
But that hasn't happened in a number of years.
That's right, that's right.
We're on the mend.
They did ban weapons in the building shortly thereafter, so. But no, I mean, in terms of discourse, I don't know if we've ever had any sort of honeymoon period. It certainly was very vicious in the 1790s, as you mentioned. I do, though, think that in the mid-1970s, you have some a period where Congress was actively trying to reassert its power through things like the creation of the Federal Election Commission, the Freedom of Information Act. 1978 was really the last major reform of the civil service, creation of the Inspector General Office, and that's within a lot of us in this room's lifetime. So, it seems like it's far away, but really isn't.
Professor Prakash?
I mean, I guess there's two dimensions. One is partisanship and one is congressional power. And I think they're in ages past, of course, Congress had more power than it did now, even if it was very partisan. And so I think if you can't have both, at least have the power. And so I think it's a mistake to say that Congress has always been irrelevant or been a plaything of, just a tag-along for the executive. That's just not true, right? There were very powerful committee chairs and speakers that, basically decided federal policy in any number of ways. And so I think that was true for most of our nation's history, in fact. So the golden age in power, I think, was centered in this building for centuries.
Well, that being the case, and we're pointing to the mid-'70s as a resurgence in congressional power, when is the failure? Are you coming to the Carter years? Because that's going to hurt me as a Georgian if that's where the blame lies. If we can point to the '70s as a resurgence, and it used to be strong, when's the weakness begin in your view?
I mean, I think it's gradual. I don't think it's any one decision, right? I mean, I think if you keep on delegating authority to the executive, it will naturally feel like it's the one who's tasked with making the laws. And then when you pass particular restrictions, it will then think it has discretion to reinterpret them, right? So even when you pass specific laws, it finds discretion where none was meant to be conveyed. And so I wouldn't blame any particular president. I think they're all doing this, and they have incentives to do it. I don't think they're evil. I think they're running on a platform and they think they want to implement it, and we can disagree with the platform or not, but I think they're just responding to the incentives they face, and I just don't think it's any one person. I think it's a mistake to personalize and say this president was the cause of all our problems.
Professor Burstein?
Yeah, so I guess pivoting off of that slightly, the partisanship and the power are really closely related. They're directly tied. What happened in the 70s was a major effort in Congress to reassert power coming off the Watergate years in Vietnam and so forth. But the 70s is where the partisanship line, where the polarization line switches. So if you look at the political science and they graph the sort of number of effectively party line votes in Congress, what happens is beginning in the 70s, the line starts going like this, right? Polarization starts going like this in the 70s. Now, why is it that happened? Beyond our pay grade here, probably, to describe those trends in society. But it's not that the scope of delegations changed in the 70s, right? We were well into the administrative state by then. What changed in the 70s is the partisanship, and the partisanship affects the power because it makes it harder for you to legislate. It makes it harder for you to act, right? And as Congress has become increasingly divided, it makes it along party lines, closely divided, it makes it harder and harder for you to act. So it's not possible to divorce the partisanship from the power. What's possible at best, right, is for Congress to act in ways that try to diffuse rather than exacerbate the partisanship that exists. Now, some of those are outside things, and they might have to do with campaign financing, and they might have to do with, say, amending the Communications Decency Act to sort of start to think more strategically about social media in a way that respects the First Amendment, but that still tries to minimize the polarizing effect of that. And part of that is, as we were talking about earlier, creating spaces within Congress. Once a week, have a bipartisan lunch and bring in an outside speaker to give you like a little history lesson or a little, right, instruction on how Facebook works, or take your pick, right? But, right, the second member of Congress, I've heard two members of Congress in the last 6 days say, gosh, I never see members of the other party. We don't meet for lunch. We don't, I've got to be back in my district raising money. I've got to be at committee meetings. I've got to be whatever else. That's an extraordinary state of affairs as a workspace for you. And it seems to me like that's a modest initial step that might begin to help Congress at least not exacerbate the partisanship that exists.
Mr. Chairman,
I'm going to want to accept Professor Prakesh's invitation. If we can't defeat the partisanship, let's at least take back the power. I hope we'll be able to work on that together. I trust you with that power. I yield back.
No, and I appreciate that, and I think that's, go ahead.
I just want to,
Yeah.
It's interesting that the partisanship came in the 70s. I think I would agree with Sy's point about how there was, even though I don't think there was a golden age, there was this point at which Congress's power were stronger relative to where they are today, absolutely. There is an intellectual shift that it begins in the early 20th century, and there's a new theory of governing about administration. There are things that occur along the way. But the fact that a big shift occurs in the 60s and especially in the 70s, I think, is significant. And it's not merely a random rise in partisanship. It's, for the first time, you now have in place a fuller administrative state. And for the first time in the Nixon administration, there's a sense that should be fought over between the executive branch and the legislative branch. And so, from the 70s forward, you've now got a situation that this administrative state largely in place, it's largely been centralized in Washington, and lo and behold, the partisanship is actually when you have an executive trying to exert their control over it, and the other party in Congress not liking that, trying to fight back. We got partisanship. I mean, in a certain sense, that's what's happening today. That's what we fought a similar battle in the 80s, right? There are these back and forth, which I underscore the point that a lot of politics today actually turns on by virtue of how it's been created. We've created this situation where it's in the interest of the executive to fight over the control of the thing you guys have created. And you guys need to pull that back, in some way to get that institutional balance in check. It has been partisanized to some extent, and that's unfortunate, but it is a serious battle with serious constitutional implications. It's not mere partisanship. It's a serious constitutional argument going on as to where do these aspects of the modern state rely, who has the proper authority over them, how are they going to exercise that authority, consistent with the broad parameters of constitutional government.
I yield to our constitutional expert, Mr. Raskin.
Mr. Chairman, thank you, and I want to thank Mr. Cole as well for your vision in bringing us together in this hearing, and it is indeed refreshing and exciting for us not to be here in the usual partisan camps of 9-4, but 13-0 on the side of the constitutional order and Congress and the people that we represent. When I read through everybody's testimony, I find that there's at least one overarching value and principle that's been vindicated by the presentations today. And I think about it sometimes when, whenever the president, any president, violates constitutional boundaries or rights, and a member of Congress will get up and say, Mr. President, please stop treating us like this. We are a co-equal branch of government, beseeching the president to be good to us. And what I take from everything you're saying is that we are not a co-equal branch of government. First of all, co-equal is not even a word, okay? That's like extremely unique or something like that. We are not an equal branch of government. We are the people's branch of government. We are the representative branch of government. We are the lawmaking branch of government under a constitutional Republican framework. And The preamble to the Constitution is that one action-packed sentence that gives us all of the purposes of government. We, the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of the United States. And then, that's all one sentence, and the very next sentence is Article 1, stating that all legislative power is vested in the Congress of the United States, the Senate and the House, meaning that the sovereign power of the people to create the Constitution, to launch the nation, to design the government, flows immediately to Congress. And then you get 37 or 38 paragraphs spelling out all the powers of Congress, as you've discussed them: the power to regulate commerce internationally and domestically, the power to declare war, the power to set up a post office, the power to exercise exclusive legislation over the seat of government, the power over piracy, and on and on and on. And then Article 1, Section 8, Clause 18, and all other powers necessary and proper to the execution of the foregoing powers. And then after all of that, you get to Article 2, which reposes the executive power in the president. And there are just 4 short sections, and the 4th section is all about impeachment and how you can impeach a president for committing treason, bribery, or other high crimes and misdemeanors. And then the rest of it is essentially saying that the president is the commander-in-chief of the Army and the Navy, and the state militias, when called up in times of actual insurrection and conflict. And what is the president's core job? To take care that the laws are faithfully executed, to implement and execute the laws that have been adopted by the people's representatives. So I want to thank you for restoring that essential constitutional vision, which has been so lost over the decades, whether you trace it to the rise of an administrative state, as Professor Spaulding does, and I definitely want to ask him about that thesis, or I think another rival and perhaps, to my mind, a more compelling proposition, which is the rise of a national security state in the wake of World War II and the development of a massive military apparatus underneath presidential power and control. But I wanted to say a word about something that Mr. Cole said, because I think that he's right, and I think he was picking up on one of Dr. Spaulding's points about Madison Federalist 10, about how the design of competing and counteracting ambitions requires those of us who aspire and attain to public office to identify our own political ambitions with those of our institutions, and to fight for our institutions and the institutional interests and principles that emerge. When that happens, that really is kind of a beautiful thing to behold. I remember when I was reading Robert Caro's book about Lyndon Johnson, who of course was a famously great and effective Senate majority leader, but when he got elected vice president, he had the idea that he would be not only vice president, but he would stay on as Senate majority leader, because he said, hey, I'm the president of the Senate under the Constitution, and I should just stay the head of the Democratic caucus. And he expected that these senators who usually yielded to his will would just go along with it. But when he went into the room to announce that this was his intention, there was an absolute insurrection, because all of the Democratic senators said, you now belong to the other branch of government, and we have to stand up for the legislative branch and for the Senate. That's who we identify with. I think more recently we've seen it a couple of times. We saw bipartisan majorities in both the House and the Senate stand up during the Obama administration for the legislation that would make Saudi Arabia liable for lawsuits by our constituents relating to 9/11 over the president's veto, and we were not distracted by the partisanship of the matter, just like more recently under the leadership of these, our chair and the ranking member. I think we have also stood up for the war powers of Congress with respect to Iran. We also did it with respect to Yemen. And so there are times when we exercise that political institutional muscle memory, and we are willing to stand up for the powers that have been reposed to us by the founders of the Constitution. But I want to ask a couple of questions, and one is about the courts. Is there anybody here, and I mean, this could even be yes or no, is there anybody who thinks that the courts can save us here or has any interest in saving us here? I see a Supreme Court that has been increasingly filled with people who've made their careers as executive branch lawyers, advancing a strong executive view of the Constitution. And that view has come to sway a lot of the Supreme Court decisions. And I'm not seeing that the Supreme Court has been in any mood to rein in executive power. So I just want to know, is there anybody out there who thinks the courts can save us? And you can answer with your silence, or Professor Prakash.
I think your general sense is right. I don't think the courts can be counted upon to save you, or put it another way, sort of do the work that you should be doing for yourselves. I think the only justice who's had any legislative branch experience off the top of my head is Breyer. I think he worked for Senator Kennedy for a while. I don't know how long. But I think you're right that if senators paid attention to this, we could have more justices who actually have served in legislatures or served in Congress, which wasn't uncommon in the past. And so I think that's certainly possible, that you could ask presidents to think more about appointing members of Congress or former members to the courts.
Great. And yes.
My own view is the court should be more aggressive in checking executive power, but not even Justice Jackson thought the courts could preserve for Congress power that Congress didn't assert for itself. So
the bottom line is we've got to do it ourselves. In other words,
Yes.
we have to exercise the powers of legislative self-help in order to defend the proper powers and prerogatives of Congress. So let's see. Dr. Spalding, I wanted to come to you. I agreed with almost everything you said, but I detected a sneaking attack on the administrative state, and I certainly heard the same thing from Steve Bannon when he came into office. I think he declared his overarching purpose was to deconstruct, I think was the word, the administrative state. And forgive me or my parochialism here, but I represent Maryland's 8th District, which is right near Washington, D.C., and I represent tens of thousands of people who work in what people are slurring today as the so-called administrative state. They work at the Department of Agriculture. They work at NOAA, which is in my district. They work at the NIH, trying to fight and research the killer diseases. They work at the Center for Disease Control, trying to prevent the viruses and bacteria that are coming to get us. I'm sorry, but I don't think that the 435 or the 535 members of Congress can do all of that stuff ourselves. I think that it is completely within the legislative prerogative to set up these agencies, which will be under the executive branch of government, to go out and to implement the will of the people in a very complicated modern society. And that doesn't mean that we have to give away our overarching legislative power and legislative supremacy within the system. Now, I'm totally with you. If we write our laws in such a way that there's a very broad and overly vague or standardless delegation to the executive branch, that should be struck down under the non-delegation doctrine. We should make sure that we are delegating laws with specific enough direction that rules can be developed. But is the administrative state itself really a problem? And I thought I'd give you at least a second to say something, and then maybe I could ask one of your colleagues to answer. Is the administrative state the heart of the problem, or is the problem that we do have executive usurpation and legislative surrender of powers that properly belong with the representatives of the people?
Well, just on your last point, those two things aren't necessarily incompatible. And so I would agree with that, your last point. But in general, I think the administrative state is a problem, but let me clarify what I mean by that. I know it's become a popular term and politicized in a certain way, which I don't completely agree with, the notions of whether it's deep state or whatever these terms are. I mean it in a very more straightforward and simple way. And I'm just raising the general observation that by its original plans, when you read Wilson and Teddy Roosevelt and people in both political parties, was to figure out how to do more and more things through kind of bureaucratic expertise outside of the political control of, among other things, Congress. That was the intention to a large extent. And here we've gotten to a point where a lot of the things that your constituents normally think of as laws are being not responsive to consent in the way they assumed for a long time, either through regular congressional elections or is there somehow consent through the executive. I think that is, at the level of principle, quite problematic. Having said that, Congress actually does a lot of things and regulates a lot of things that it has to by the necessity of government. So I'm not denying that it's extremes one way or the other. I think that if we're thinking about this discussion here, it is problematic because there's now this huge array of government that Congress is trying to figure out how to, through its lawmaking power and oversight, how to keep an eye on it. There's a lot of it. It's very complicated. It's a hard thing to do. And by virtue of that fact, you have a lot of it that now is occurring under the executive, who has more and more authority to shape a lot of those decisions through political appointees and other processes. I think if we're thinking about how to revive a robust separation of powers in a way that is ultimately politically responsible through consent, which is really the objective I think we all share in common, it is something I'm comfortable with. But I'm not saying that we want to go back 200 years and have this little. That's not going to happen, and that's not the objective. It would be imprudent to do that. But I think that we're beyond the point where Congress needs to really think hard about how to, when you create something, maintain control of it. It should be responsible. It should be responsible back to you. And if there are things going on in the state that you don't like or you want to check, you should be able to have a ability to call those things back and to check them. And I think that the less you do that, the more the executive will. Hence, we have the situation which we find ourselves. And that's not to say there are other factors here as well. It's just looking at it from my historical point of view, that seems to be a major factor here that tracks very nicely historically with the rise of the problem we're looking at.
All right, good. All right, let me.
Mr. Rice, can you just yield to me 1 second?
Yep.
Yeah, I just want to, I have to excuse myself to go to the floor to, I have a bill on the floor, but I'm going to turn the gavel over to Mr. Cole. I didn't want anyone to have a breakdown on our side. But I mean, this hearing, again, is a.
Your dad giving the keys to the car, but he still owns the car.
Should we appeal the ruling of the chair?
You can, but anyway, all right.
I think you got the votes.
All right, I just have two final questions. Professor Prakash, let me ask you, one of the other themes that has emerged strongly here is that Congress has the power to declare war, but it also has a duty to declare war. That is, we can't abdicate or surrender that just because it's a politically difficult position for us. And I wonder if you would just generalize that proposition in terms of all legislative action here.
I think so, Congressman Raskin. I think this goes back to what Congressman Woodall was saying. I think the Constitution gives you authority, and you're supposed to exercise it, and that's true for war powers. I would say it's equally true for the other things that are granted to Congress, the regular legislative powers. And you're quite right that you don't have the expertise that agencies have, but I think you can harness their expertise without fully delegating your legislative powers to them, I think, as has happened. And I think it's sort of interesting and emblematic that the president, I think last year or the year before, said we're going to dismantle Obamacare administratively. And I think that's an incredible statement to make, but it's actually possible that the statute does give him so much discretion that he can do that. And I think that's a consequence of a habit of just saying, look, we do the broad outlines, you do the details, but that has consequences for how the executive branch conceives itself. And of course, it's then impossible, it's virtually impossible for you to change that statute.
Okay, and my final question, and perhaps Professor Pearlstein and Dean Belmonte, you would address this. But one of the reasons why the executive branch, I think, has grown in power vis-à-vis Congress is the executive branch has one person at the top of it, and that person can speak for the entire executive branch, and it communicates a sense of authority and command that you don't get from 535. I mean, when I read the founders, I think one of the things they loved about Congress was that people would come and they would debate and fight and talk. And yet it's very easy to run against an institution that just talks, that is just debating, that is just deliberating. And all of those trends have been pronounced and exacerbated by the rise of modern technology, TV, internet, Twitter, and so on and so forth. So I just wonder if you would reflect on symbolically and in terms of communication, how to rectify the imbalance between the branches that has grown up.
You want to go? Okay. That's a great and interesting question to which I'm not sure I have a very good answer. Theodore Lowy, former professor of mine at Cornell, wrote about the personal presidency, right, decades ago. And you could date it back to Teddy Roosevelt, right? So this is a radical change. One of the things that's been most interesting to see, and forgive me for mentioning the current presidency for a moment, right? This is the first tweeting president, right? And I think that's factually accurate. That of itself, right, empowers the executive dramatically as compared to any member of Congress or even more. Congress has to be enormously cautious when it begins to think about regulating those privately owned platforms. But those privately owned platforms, Twitter and Facebook and Instagram and the whole pile of them, exercise an enormously concentrated degree of power that historically the United States has been uncomfortable allowing to be held by any one body, right? We separated powers in the federal government, we separated powers between the federal government and the states, we have antitrust laws that prevent the accumulation of powers in private industries, and we are at a moment when, in part because we don't understand this industry very well and we're still trying to follow it, where it is effectively further changing the balance of power even among the branches of government. It's something that Congress has a duty to at least begin to get a grip on or understand, and then to think creatively with members of private industry and academia and so forth, how we might begin to more effectively incorporate those kinds of institutions into our political life.
I think that we've had a real evolution of how presidents communicate with the public. You know, one could make the case that Twitter is the new fireside chat of 2020. Some of the things that I think Congress could do, Professor Pearlstein mentioned the antitrust laws. I think there certainly is a case to be made that some of these companies now wield a tremendous amount of power. We've had, I think there are like 6 major companies that control most of the newspapers in the United States now. Possibly consideration of the reinstitution of the fairness doctrine might help write this picture a bit. I also think there are some things we can do to empower the people in the National Archives system who are working for records retention and openness, bolstering the staff of the people who implement the Freedom of Information Act. Both of the National Archives in particular has really had its budget gutted, and with the flood of FOIA requests, that sometimes brings the administrative state, people who could be doing things that are more productive than fielding these requests. That has really been a considerable issue in the last few years.
Yield back.
Would you yield me just a moment?
By all means.
Thank you very much. I just want to follow up on a point that you made, Professor Pearlstein. We recently were at a Republican retreat, and somebody said, if you want to see who's got the louder voice, let's add up all of what you guys have on Twitter, literally every single Republican member, and what the president has. It was a 10-to-1 differential. So in terms of megaphone, really makes your point. With that, gentlemen,
And I yield back to you, Mr. Chair.
Thank you very much. I yield to my good friend, gentlelady from Arizona, Ms. Lesko.
Thank you, Mr. Chairman. First, before I forget, I'd like to ask unanimous consent to insert into the record a report for a practical vision on government efficiency, accountability, and reform that the Republican Study Committee, of which I'm a member, produced. It offers over 100 solutions, many of which include reasserting Congress's proper role in regulatory reform. Thank you. I think this has been an interesting discussion. We'll see if anything comes of it. One of the things, I have a question for Mr. Spalding. I think one of the things that I heard going in and out between different committee hearings that I'm in is that there is a suggestion to beef up the staff. And so have kind of a nonpartisan alternative to the Office of Legal Counsel in Congress. And what are your thoughts on that, Mr. Spalding?
Well, I was speaking in general terms first, which is that I think that Congress shouldn't unilaterally disarm in the kind of back and forth with the executive branch, or for the judiciary for that matter. It should have the strength it needs to do its work. Beyond that, it's a prudential question as to what exactly you need. You create this congressional budget. What is it that would help you best fight those battles? I think that's just a practical question. In terms of having some sort of Office of Legal Counsel, I don't see that necessarily as a problem. Why wouldn't you? I mean, I think the point. I was going to tell Mr. Raskin I'm going to blatantly use his wonderful phrase, legislative self-help. I like that, by the way. That's great. I'm not in complete agreement in the sense that each branch is, Congress is first among equals, but each branch has a separate vesting and takes that vesting seriously. And so it needs to have the tools to carry out its responsibility. If Congress deems that it has need of these things for that purpose, I think that's a perfectly legitimate reason to do so.
And I'd like you to expand. I know the power of the purse is probably our biggest leverage that we have dealing with the executive branch. And this was a case, I was in the Arizona State Legislature for 9 years. The same struggle happens between governor and legislative branch. You know, the governor wants to take all the power, a legislative branch, usually gives it to him. And so you had brought up something about, could you expand more on the budget subcommittees and maybe, if I heard it right, changing them up so they're not really in line with the presidential budget, but some kind of strategic?
I was just making a general point, and my guess is you guys know all this stuff better than I do. I'm not a budget expert, but I'm looking at it from a political point of view. And I think it's the case that the control of the budget in the modern era determines the control of government. Mm-hmm. And that power has shifted a lot to the executive branch. Mm-hmm. One reason why you might need more people to help you do that. But also then you start thinking practically about how should Congress exert its power. And I've told this to previous Congresses as well. The Congress waits and waits and waits, and you get into these omnibus situations, and lo and behold, those almost inevitably get won by the executive, right? Your power is actually doing the old-fashioned work of committee work and budgeting and authorizations and the back and forth, because if you do that, number one, it's more likely you're going to have a pretty strong agreement about where you are on the budget and the particulars, and there's no reason why you can't pass them why do you have to pass them in a particular order? You could break them up into different pieces. You could pass 100 little budgets, as far as I can tell, right? My point is you should think strategically about what's the best way to do budgeting, not merely as a budgeting exercise, but as a political exercise in terms of how do you best exert your constitutional powers as an institution vis-a-vis the executive. And I think it is your strongest power on the one hand, and you should go to your strength. But number two, you should think creatively about how to use that power. And I think there are a lot of ways. That was just an example. I could be wrong about it, but that's an example. You should think strategically about how to exert that power that gives you more leverage. So when it does come down later in the budget process, you're not caught in a position where they're going to win. You've already done the things, and you've got under your belt the things you want to get. You've got, right? Just think strategically. That's my own point.
Well, thank you, and I yield back.
Before we go to the gentlelady from Pennsylvania, just quickly as a reminder, everybody, we're supposed to vote around 1:30, so just wanted you to be aware of that. Gentlelady from Pennsylvania, Ms. Scanlon.
Okay, thank you. I want to thank the chair and ranking member for arranging this. It's a really interesting, as you've noted, bipartisan hearing to address something that Congress appears to have allowed to happen on a bipartisan basis over many, many years. I wanted to focus a little bit on the National Emergencies Act. We had actually had a similar hearing in Judiciary about a year ago, which also involved high-level constitutional discussions on a very bipartisan basis. The Congressional Research Service tells us that since that act was passed in the 70s, 56 national emergencies have been declared by 7 different presidents, and that 60% of them are still in effect. So a couple of you mentioned some possible fixes there, and I wanted to look at them. Professor Pearlstein, I think you talked in your remarks a little bit about maybe narrowing the delegation of power. Can you speak to that a bit?
Sure, and thank you. And in fact, I think there are a number of bills that are in the drafting stage that might effectively amend the National Emergencies Act. Let me mention 3 ways. First, the way, or 3 potential approaches you might take. The first is narrowing or indeed defining at all what an emergency is, which the current act doesn't do. And you can come up with some definition of emergency that doesn't unduly constrain the executive, right? The point of emergencies is to have some more flexibility than the executive might otherwise have to respond to contingencies that are unanticipated. But at the same time, countries around the world have adopted, either in their constitutions or as statutory authorities, emergency provisions that say things like, this has to be something that, for example, threatens the life or the economy of the nation, or this has to be something that is reasonably anticipated to be of limited duration, right? This is not an ordinary tool of, say, economic sanctions or the way we conduct foreign policy every day, right? So actually defining emergency, I think, might be a useful first step. I think it's critical to flip the switch of authorization, by which I mean currently it takes, in effect, a supermajority of Congress to terminate any emergency because it has to be a joint resolution, right? I think emergencies should terminate automatically after a certain period of time unless Congress acts affirmatively by simple majority vote to reauthorize them, and again for a certain limited period of time, I think is essential. One other point I'll just mention here, and I think I might have mentioned others in my testimony, but I'm happy to talk about it further. There is no current provision in the National Emergencies Act legislation that requires, so once the president declares an emergency, it triggers access to 130-something different statutory authorities that might be used. There is no current provision in the National Emergencies Act authority that says you may only use those statutory authorities that are relevant to solving the emergency that you have identified, right? So we could, under the existing statutory scheme, be in a situation in which the president declares, or actually the health emergencies work differently, but just to use the coronavirus example, in which an emergency, a public health emergency is declared, and for that reason, we take additional funds to do military construction on the border, right? So I don't mean to be partisan. I'm choosing these examples from current history, but the point is, right, the president doesn't need every emergency authority in every emergency, and it is entirely possible to draft the statute through minor amendment that would make the president only able to use those statutory authorities that the president determines are necessary to address the emergency as identified.
Okay. Professor Prakash, I think in your comments you talked about maybe a 6-week sunset provision. Can you speak to that a little bit?
Well, I mean, I agree with much of what Professor Pearlstein has said. I think a definition of emergency would be good in statutes. But I think the time frame is crucial, right? Because it's sort of embarrassing that presidents are basically saying we've been in a state of emergency for 60 years, because it just sort of drains the word of any meaning. So I think saying that, look, sometimes Congress is not in session, you need to act, fine. The emergency you've declared and the authorities you're exercising will expire 6 weeks after Congress returns or 3 weeks after Congress returns. The Constitution itself has this provision. It's about recess appointments. It's supposed to end at the end of the next session of the Senate. I don't think you need to give the president a year-long emergency. I think a couple of weeks should be sufficient, and then members of Congress can just decide, is this really an emergency? Or even if it's not, do we agree with the policy such that we want to implement it statutorily?
Okay. I was struck by, both in your conversations and in the comments you submitted, the number of recommendations that overlap with the other committee that I serve on with Representative Woodall, the Select Committee to Modernize Congress, where we've talked quite a bit about ways in which we can develop more room for discussion, for legislating, for bipartisan discussions. And these include calendar adjustments to increase the time in DC, longer work weeks, restoration of earmarks, and staff resources. I think, Dr. Prakash, you talked about Congress needing to bulk up on its staffing. Would any of you care to address that?
I completely share the recommendation that Congress is understaffed, significantly understaffed. And so both within individual offices and as an institution, Congress has the capacity to create Congress has the power to create all kinds of additional capacity that it needs. What happens sometimes now is that members of Congress in offices that are short-staffed or require expertise pull from different agencies in the executive branch who have wonderful experts in them. But it should be possible for Congress to maintain and pay the kind of expertise, the kind of expert staff that it needs right here in-house.
Yeah, I think that's been kind of one of the frustrations as a new member. I think I disagree a little bit, and maybe it's because 2 out of the 3 committees I serve on are aggressively bipartisan about not having the opportunity to speak with or break bread with other members that frequently. But the pace of our time in DC with kind of a very compressed four-day schedule where members have to step in and out just to get to the hearings and such, I think is problematic, and I'm hoping that we can make some movement in terms of the calendar system here. And with that, I'd yield back.
Thank you, Mr. Morelli.
Thank you. First of all, I just want to comment on how much I appreciate this forum. I appreciate all of you being here and your thoughtful testimony, which I had the chance to, like Mr. Cole, spend time over the weekend reviewing. I also want to thank the chair and ranking member, who I think have done just a great service to not only to us on the committee, but to the country by having this discussion. I, like my colleague, Ms. Scanlon, and Secretary Shalala, are new to the Congress. I served in the state legislature in New York for more than 2 decades, so trying to get acclimated to the Congress and how we work. But as I was thinking about this over the weekend, I had sort of 3 things, I think, generally that came to mind. The first was how to restore the balance that the founders intended, which is what all of your testimony was about in the background material. And I want to also thank the staff, because I think they did just a terrific job in pulling materials together in the Congressional Research Service. So thank you for that. But how to restore that balance, and spent a fair amount of time reading through the material and sort of thinking about it, recalling times we all read through the Federalist Papers in college. The second was, if the question of restoring the balance is obviously a critical one, the point here, but then also secondarily, does what the framers intended, is that still work in the modern world? So is that balance possible to restore, and then is that the right form of government in a modern world? And I think about it under sort of 2 sort of general ideas. One is feasibility, with the issues that we have to deal with now. The how quickly things develop, and you compare that to the 18th century, where things moved at a relatively modest pace compared to today. So today, within just a few weeks, we're talking about a virus that a month ago few Americans had paid any attention to, and now it's dominating just about every news cycle, and obviously there's concern about how quickly we react to it. Talked at length today about military action, and again, just the ability to be able to engage in military action compared to just 2 centuries ago, and the complete difference in the ability to reach enemies, and now with air power and missiles, et cetera, it's momentary rather than taking weeks, if not months, to sort of engage. And I think about even feasibility, our appropriations process, which I had the privilege of now, I guess, working through too, but the last one, we finished our appropriations process in December for a fiscal year that starts October 1st. So, I mean, our ability to sort of come together and deal with it. So that's one thing. Second was, and I think Mr. Cole and Mr. Raskin touched on this in particular, sort of the practicality, given where the media is, and I don't mean just the traditional media, social media, just the ability now for people to share information and to hold us accountable in ways that, frankly, would never have been held accountable. I go into meetings in my office in the federal building, meeting with constituents, and they'll say, why aren't you a co-sponsor of this bill, which I've never even heard of, and it's almost as though it's weaponized now if you don't know every single, I don't know how many thousands of bills are introduced, but it's amazing the degree to which people not just hold you accountable in sort of broad brush, themes about your philosophy of government, but in very pointed ways about the issues that they care about. And if you haven't sponsored or co-sponsored a bill, if you haven't signed on to a letter, honestly, the volume that comes at us, and I don't know that I'm any different. I'm sure the senior members get much more attention, but it makes it nearly impossible to manage all of that. So I wonder about the practicality of some of the things that we've talked about. And then I think the final thought that occurred to me was, I was reminded of, I think it was Walt Kelly, who was an old cartoonist, who modified an old phrase that we have met the enemy and he is us, which is Congress can act. I mean, we talk about a lot of ways of sort of forcing us to do what is our job under Article 1. And so I do think about that. I mean, it's almost like we're creating a Rube Goldberg sort of machine to get us to do what is our constitutional authority, which we have the ability to do. I did note in looking at this, I was trying to remember an old Thomas Jefferson letter, which my staff put their hands on, thankful to them, that he wrote to James Madison. He was in Paris at the time, wrote in September of 1789. He said, on similar ground, it may be proved that no society can make a perpetual constitution or even a perpetual law. And he sort of gets into the conversation about with himself of the question of repeal versus what we would call today a sunset provision. He said every constitution then and every law naturally expires at the end of 19 years. Don't ask me where he came up with 19 years. It's sort of an interesting, I guess that's a generation in that era. And then he sort of concludes with a law of limited duration is much more manageable than one which needs repeal. And his argument being you'd have to have a majority and you'd have to have a president to sign a repeal or to agree to a change. Better to have a sunset. And so I think some of what we talk about sort of falls along the lines that many people have opined on here, that sunsets may be the best way to sort of address this because it is so much more, I think, it's just so much easier for us to periodically, and I don't know whether depending on the bill and depending on what we're dealing with, whether it's every 5 years, every 10 years, or even lesser timeframes. I did want to ask a question. I don't know that anybody's asked, and I had to step out, so it may have gotten covered. But since I'm not burdened by a legal education, I don't know the answer to all the questions I ask. I know lawyers are supposed to know the answer, but I don't know the answer to this. But I'm just sort of curious about executive orders and whether or not if any of the panelists wanted to just make any observations about the proper role of the executive order and whether in the modern era they've now begun to expand into what are sort of legislative prerogatives and whether or not we ought to be doing anything from a statutory point of view in terms of putting limitations on executive orders. Any thoughts on that?
I think it's a wonderful question, Congressman. I tell my class that it's not the vehicle that that matters. It's what's said in the order, because you can call it something else and do do the same thing. And, an executive order is legal or not, depending on whether the president has constitutional or statutory authority. And so those are the underlying questions that really matter. I think presidents have directives, they have a bunch of documents, and, they used to have proclamations, they don't have them as much anymore. But I don't think focusing on the form matters. I think I think it's more helpful to think about, well, do they have authority to do this? And whether they do it or the agency does it, that's the ultimate question, because sometimes presidents tell the agencies what to do and then the agency does it, but it's really a presidential initiative. It's not coming from the agency.
So, yeah, go ahead. Thank you. I'm sorry.
So the most important thing that Congress can do with respect to executive orders that it doesn't like or doesn't agree with is override them by legislation, right? It is the simplest fix in the world, the simplest constitutional fix in the world.
Well, isn't it, I guess what I was curious is whether you observe that there's been an expansion, not only of the use of executive order, of whether executive orders are becoming bulkier and starting to really press into us. And I acknowledge that the Congress could always repeal, but I assume you'd have to do it by statute and you'd have to require the signature of the president who had signed the executive order in the first place.
That's true, right? So it becomes difficult. And there are also ways, and the way it usually works these days is that they're challenged in court, right? And the courts move faster than Congress tends to move on these things. But
Potentially.
yeah, right. So in many circumstances, with respect to sort of long-term executive orders. But I don't know, and I'm sure there's political science on that, and I don't know. Executive orders have been with us for a long time. We may get them more frequently now than we used to, but we have had very broad executive orders, and they were indispensably important in the mid and early 20th century as well, certainly surrounding the wars that we fought. So executive orders have been around for a long time.
Yeah,
It's
I think
Congress
Washington
acts. Congress act, it's not necessarily that the executive is acting so much more through executive order or something, it's that Congress is acting less.
Any other observation?
I would echo that. I think that the sheer volume of them that has vacillated over time, but I think in the current legislative landscape, they're being used in the absence of legislation to address some very contentious issues. Probably the best example of late would be immigration. We haven't had substantive national immigration legislation since 1986, and LGBT rights is another area. And by doing a lot of this through executive order, it's putting the courts in the place of trying to interpret how to implement these orders and trying to guess what Congress's intent might have been had it acted, but not having the legislation to have a clear affirmation of that.
Yeah.
I actually find myself, I think I would agree with everything that's been said here. I think you're going to get the increase in the amount of executive orders when the executive has more things over which they are responsible, and they use this mechanism, whether it's an order or some other declaration, to give instruction to those who are going to execute the law. That is, they're actually carrying out their obligations to do so. But to the extent that there are discrepancies or things that need to be interpreted or areas where there's some discretion, right, they can use those mechanisms as ways to shape the meaning of the law, at the very least, if not do something contrary to what Congress wants if Congress fails to act. So I don't think they're necessarily a new and different problem in and of themselves. I think they're really part and parcel of everything we've been discussing here.
Yeah, and I won't go on much longer. I just want to, I do think the points made about specificity in legislation is important. I think when I was in the state legislature, I chaired the insurance committee for a while, and I noted every bill that would be proposed by the governor would give all these basically unlimited powers to our superintendent of insurance, which I would immediately take out before we would enact anything, because I do think it is important for legislators, that if you're writing laws, not to simply delegate the details. Now, some of it you're going to have to, obviously, by rule, but I think we would be better served to have much more specificity in what the Congress's will is and give less latitude to the executive branch to do that. And I also, again, I think I looked at the, something like 25% of the American public follows the President Trump's tweets. Roughly a little bit higher percentage follows President Obama's tweets. And I think I forget who made the point here, but individual members of Congress don't have the ability. The nature of what we do now is dramatically shifted, and the nature of communications where a president, probably up until the relatively recent history would have to go through what was traditional media. I mean, when I was a kid growing up, you watched Walter Cronkite every night, and whatever you saw on CBS News or the other networks was really the way that was communicated from the executive of the White House, and by the way, from Congress to the American public. But now it is so much different that the president's ability, and I don't think the founders really thought Congress would be the voice of the people, right? In one of these, talked about how each branch, from Article 1 to Article 3, each branch was less sort of the people. We were the branch that was to be chosen by the people, the executive by the Electoral College, which would be the will of the people in the individual states, and then the Supreme Court, obviously through the president's nomination and ratification by the Senate. But now it's really changed in that the ability to go directly to the people is much more enhanced by the White House or by the president, or any president, than it is by individual members of the House and even of the Senate. And that's had a dramatic impact on the way that we do our work. And I'm not sure we can ever put that genie back in them. I doubt we can.
But it's also injected a whole new level of ambiguity. Is a tweet a policy statement? And that has created endemic confusion on more than one occasion, both within our country and among foreign countries. And it may be an area that Congress asserting itself could add some clarity as to, what does constitute an official action of the U.S. government?
Well, I think it's a great question, and obviously I don't think this president is going to be the last one to use Twitter or other ways of communicating directly with the American public. I mean, I think that's just the way it's going to be, and I think you raise an important point. So anyway, I'll conclude. I have many more questions, but I'm not sure they would in any way add to the debate here. But I do want to again thank the chair and the ranking member for, I think, a really, really important conversation.
Mr. Lillo.
Thank you. I share my colleagues' view on thanking both of you for a really important discussion. I have been on the other side, on the executive side, and now on the legislative side. I've not been on the judicial side, but I understand, and I want to point out to my colleague from New York that the Supreme Court does not require a law degree for appointment. So.
I don't think I'll be a candidate, though, anytime soon.
So one way the Congress delegates authority to the executive branch is also by badly drafted legislation. And as someone that sat on the other side, we would somehow celebrate a badly drafted piece of legislation because we could drive a car through it and do whatever we thought was best, or by delegating a responsibility directly to the executive branch when they didn't want to make the decision. And my example there is when Congress did not want to decide whether individuals should be able to import drugs from another country, they said to the Secretary of HHS, okay, you can do it as long as you're willing to say it's safe and that it's cost effective to do those two. Which put the secretary in the bind as opposed to Congress in the bind. And I could go through numerous examples, including HIPAA, where the Congress could not agree on Kennedy-Kassebaum. They agreed on the legislation, but not on how it should be drafted and what the guidelines ought to be. So it was sent over to the Secretary of HHS to do those kinds of things. The only point I want to make that is about staffing. We are totally dependent in the legislature on the executive on telling us whether something actually can be implemented, or on special interest groups, because we don't have the level of staffing to talk about what the implications are, what the impact of various policies would do. Now that suggests not only do we need additional staffing, but we need a certain kind of staffing. It does me no good to have a conversation with young staff people who have some policy chops, they think, but not necessarily can think through what the implementation challenges are, what the implementation, and who ought to implement it, and what their level of expertise needs to be done. I was once taught by a very smart secretary early in my career that we should stop writing regulations for people that have graduated with honors from Harvard, as opposed to smart people who didn't, that needed to be able to implement those kinds of regulations. And I just wanted to make that point. And my final point before I ask a question is about the coronavirus. With all due respect to my distinguished colleague from Colorado, I actually don't think it should be an emergency anymore. I think we're going to see these viruses all along, and what we have to talk about is readiness, and whether the government is permanently funded for readiness to be able to have the flexibility to be able to deal with each of these viruses as they come along. Now, we do have some experience in that, and I want to ask Professor Perlstein about that. The Stafford Act, which was written actually for the creation of FEMA, actually has real limitations when an emergency is declared by the president. So it's possible to release flexible funding, both resources as well as personnel, in a limited emergency act, which we could use as a backup to permanently funding on something like the coronavirus. And I wanted to ask your comments on that possibility as opposed to just these never-ending emergency situations.
Thank you. So I mentioned that other countries had drafted emergency legislation and in other constitutions as well. Congress has drafted other emergency legislation that remains on the books that is vastly more specific and I think effective in constraining the exercise of executive power than the National Emergencies Act as such. You mentioned the Stafford Act, for example, the Public Health Emergencies Act, I forget the acronym exactly. But some of these are vastly more specific in, delegating power to particular officials, requiring the exercise of particular expertise, limiting, defining terms like emergency or necessity, and limiting the kinds of power that are going to be that are going to be exercised. So we have models that are at our fingertips, literally, and I think we would be foolish not to rely on them. The trick with the National Emergencies Act and IEPA, the International Economic Emergency Rate, whatever it stands for, yes, is that these have become, instead of tools for dealing with actual emergencies, dealing with chronic, long-standing, ordinary exercises of government power. When and under what circumstances are we going to impose economic sanctions or trade sanctions or travel restrictions on countries that are doing things that we disagree with? It is entirely possible, and indeed, I quite agree with you, necessary to do both at the same time, to have emergency powers that exist for certain limited periods of time as we deal with a particular crisis, and at the same time, make sure that we are funding and maintaining not only the institutes that enable us to deal with emerging infectious diseases, which happen all the time and have always happened and are likely to get worse, but that enable us to deal with global public health surveillance and other things that we might want to be able to do all the time, not just in emergencies. Both are necessary, but at the moment, we do a lot of our ordinary policy making through these emergency authorities.
Now that I've admitted that one way Congress delegates authority to the executive is by badly drafted legislation, also by making legislation more complex. And I wanted to ask you all about Chevron, because it gives the executive tremendous powers, it seems to me. And now that I'm on the other side, I'd like to find a way in which we could reverse that and at least get more balance in the system. But that also means that we have to stop drafting bad legislation, not bad legislation, but badly drafted legislation, and making legislation more complex, like the Medicare Act, by adding layers to it that actually gives the executive more control. So could you comment on that, any of you?
I mean, I think I agree with you, Representative Shalala. I think if Congress wants to delegate, it can do so. Chevron is basically a presumption of delegation to the executive. And I think Congress can easily change that by just saying we only mean to delegate when we say the following words or when we say we're delegating. And Chevron is just a rule of construction that the courts came up with, and we hereby repudiate it. And I don't think any court would continue applying it. And the effect would be that the courts themselves would decide the best interpretation of the good and messy statutes and not the executive, which would yield more stability and prevent this sort of attempt to try to make a muck of a statute. I think executive branch lawyers now strive to find problems in a statute so they can then say, look, there's a mess here, and we're basically being told to fix it through interpretation.
So I don't disagree with any of that. My former boss, Justice Stevens, who I had the honor of clerking for, is the author of Chevron and often said during his life that he never imagined or intended that it would become this new rule of construction and deference to the executive. Rather, he thought he was restating the rule that pre-existed Chevron, which was, look, if the interpretation is reasonable, then courts are in a position to endorse that interpretation, but where interpretations are unreasonable, we won't endorse them. And what makes reasonableness an executive branch interpretation is, for example, reference to record evidence and deference to expertise. And where those things are lacking, then the interpretation is much more persuasive. This is an unusual time to begin reversing major decisions of the Supreme Court. I'm a believer in stare decisis, but I'm equally a believer that deference is warranted where deference is deserved, and where you lack an internal executive branch process that came up with that the interpretation, or where you lack an internal executive branch referenced expertise or basis and expertise that actually supports that interpretation, then it makes much less sense.
Thank you. I think that's it with the questions, but I'm going to yield to Mr. Cole if he has any closing remarks.
Yeah, just quickly, and I want to pick up on something my good friend from Florida said, just so you're aware of this, and for the panel. I mean, sometimes Congress actually does what it's supposed to do. For 5 years in a row, NIH funding is up almost 40%. CDC, 24%. Strategic stockpile, 35%. New infectious disease, and I say that simply because that was a conscious congressional policy that no matter what President Obama asked for or President Trump asked for, we were going to be prepared in these areas for exactly what's happening today. Now, we can debate execution or whatever. You really can't debate resources. And that's Congress deciding. Matter of fact, I can just tell you, I had this discussion with now Chief of Staff Mulvaney, who was an OMB, and said, this is going to happen, I was chairman at the time, this is going to happen. Now, your budget can reflect it, in which case you can take credit for it, or you can be really stupid and propose a cut, in which case you're going to get beat up for it. I'll leave you to decide which one he did. But it's going to happen. And for those of you that worry about how the budget wars go, and with all due respect, the appropriations wars to be more accurate, we win a lot more than we lose. Just go look at the presidential budget at the beginning of the year, which I will tell you, having helped draft executive budgets before, it's never a real budget. It's a statement, a political gimmick anyway. But nothing like that emerges at the other end. And it doesn't matter if it's President Obama or if we make them submit a budget so we can change it and sort of we get the last word on that. So there's a lot of assertion of congressional power that actually goes on here. And so it's not quite as atrophied as you think. Our biggest problem is when we abdicate, when we don't do things like immigration, or when we don't do things like entitlement reform that we all know need to get done, and we don't arrive at a compromise. So we can do that. But I want to get more to the point. Just number one, thank all of you. I know you clearly put in a lot of work thinking through the papers. Testimony has just been excellent. We really appreciate the commitment of your time, your expertise, and your thoughts. It's incredibly valuable. I think you've noticed just from the participation of members how much they've enjoyed thinking about being members, thinking about the institutions, wondering, again, how we could do our job better in a bipartisan sense, even when we have disagreements, wondering how we could restore the appropriate constitutional balance. I think a lot of you have tremendous suggestions in that, which I hope, Mr. Chairman, we sit down seriously. Everything from, actually putting time limits on emergencies to some of these other things. I don't see that those should be partisan things that we can't do together. And finally, Mr. Chairman, I just want to thank you. I mean, this discussion doesn't happen if you don't convene it. This is, for the panel, way outside what we normally do on the Rules Committee. I mean, this is the Speaker's Committee for a reason. Everybody up here is either appointed by the Speaker or the Minority Leader. We don't go through the normal confirmation process. Our job is really to shape the legislation for the majority so it can move it, and for the minority just to offer the first line of defense and the first argument back. So this, for us to undertake something like this, is a very, very unusual thing, and it would not have happened were it not for our chairman and his concern, long-term concern about the institution, the appropriate balance, and be willing to use this as one of the appropriate instruments to bring it up. So, Jim, I'm very proud of you, very proud to be on this committee as your colleague, and very much thank you for what you've done here. I think it's a real contribution.
Well, I want to thank the gentleman from Oklahoma, my friend, for his comments, and I want to thank everybody in this committee because, as you can see, I think maybe because we're on the Rules Committee and we meet more than any other committee, and we see every piece of legislation that comes to the floor, good, bad, and ugly. That I think we're especially committed to this institution, on this committee, there's the range of political ideologies, from left to right and everything in between. And there's lots of policy differences that we have, but I think we all believe that, over the years, that we have given up some of our constitutional authority in a way that is not good for the people we represent. I think it's not in keeping with the Constitution. It's just not good for the country. And there are many reasons for that. We talked about a lot of that today. But the Rules Committee is also a committee that deals with issues of procedures and processes. And so, to the extent that there are tweaks or changes, in how we approach some of these issues, this is actually the right committee to be talking about all this stuff. And I look forward in the coming days and weeks to work with Mr. Cole and others to determine what the next steps are. Some might be low-hanging fruit, and we might be able to move more expeditiously on those. And our subcommittees can kind of delve more in detail on some of these subjects. So the whole point of this is not just to have an intellectual discussion on, whatever. It is to actually figure out whether we can actually take some next steps, actually change things for the better. The final thing I would say to all of you is thank you so much. As you probably have noticed, I'm sure you've testified before other committees before, other committees have time limits. You have been here like, not here, not here. And I want to be very honest, just kind of keep this to yourself. But we sometimes have very, very long hearings here. And sometimes, oftentimes it's members of Congress that are sitting where you are testifying, and they go on and on and on and on. And I'm going to tell you this just between us, that there are sometimes I look at, when it goes on forever, I look at the chandelier and I'm like, I daydream and say, please fall. Let's end this. Right? It has never happened, but I want you to know, and I mean this as a compliment, not for a second did I think that during this hearing today. That is the highest compliment I can pay to all of you, and I really mean it. This has been very helpful, and we look forward to working with you, as we flesh out some of these ideas that Mr. Cole alluded to. Because
I don't think I'll ever look at that.
Yeah, but just keep it in this room, will you? Okay. With that, the committee is adjourned. Thank you.